And my understanding is that we've got 3 kids in the mix. There was a divorce in 22 in Cobb County. Custody was modified in DeKalb, I think, in September of 24. You all have litigated the wait. It hasn't been 2 years yet. And Judge Ellerby said, based on the pleadings, there's a basis to move forward. And I think, Ms. McCormick, you acknowledged, if this got dismissed, it could just be brought back in now about a month. So why not just address the issues and see where we get? And my summary isn't necessarily accurate. It's meant to let you know what I think the issues are so that if I'm close, you can spend less time trying to orient me. But I'm going to say Mr. and Ms., even though you're both doctors, because if I say doctor, we're not going to know who we're talking about. Mr. Deal believes there should be a decrease in the amount of child support he pays because one, he is engaging in more parenting time, and a nanny that is part of the payments that are being made is fewer hours of his or her time is needed because of this shift in parenting time. Ms. Deal disagrees with that and thinks that there ought not to be a reduction in the child support. That's sort of a high-level overview. Obviously, we need to get into the facts and circumstances and all that, but I think that's what we're working through today. Ms. Hanrahan-Freitag, is there anything procedurally we need to work through before you give an opening, if you want to give an opening, or you call your first witness?
No, Your Honor. The one clarification to what you shared, or modification, was out of Fulton.
Out of Fulton? Okay. I don't know why I have DeKalb here. All right. Ms. McCormick, same question. Anything procedurally we need to work through, or like Judge, actually, my client's not a doctor. She's an airline pilot.
No, Judge. I think the only point is that I had filed a notice of conflict, and that conflict's been resolved. It was for this case one under the conflict rules, but the other status conference was to take place at noon. So in case Your Honor was considering breaking around the time that I could report to that other case, it's already been resolved. It's been reset for October.
Great. Thank you for flagging that. We will have a lunch break if we're not done by then. It'll be a little later. I have a 1 o'clock Zoom, and so that I don't make your lunch break 2 hours, we'll just take it a little closer to 1. And while you guys are eating, I'll go deal with that meeting. So with that, Ms. Hanrahan-Freitag, when you're ready.
Your Honor, thank you for hearing us this morning. I have the pleasure of representing Dr. Mr. Kyle Deal. He uses his middle name, Kyle.
Okay.
And we are here seeking a reduction in child support. Very simply, Mr. Deal is spending more time with the children than outlined in the party's 2024 modification. Exhibit 4, the child support addendum from 2024, page 4 into 5, lists Mr. Deal as spending 117 overnights with the kids. The kids are with Mr. Deal spends about 173 overnights with the kids. It's a difference of about 15% and is sufficient to bring us before Your Honor. Beyond applying the parenting time deviation, we are asking for guideline child support. Mr. and Ms. Deal are both W-2 K-1 earning employees, and their income is rather straightforward. Ms. Deal pays a reasonable premium for the children's health insurance, and that's what we ask be included on the child support worksheet. As you noted, the parties have 3 children, Sylvia, age 8, Jamie, age 7, and Lily, age 5, and all are in school. My client works a traditional 7:30 to about 6 o'clock schedule, Monday through Friday, with limited call. Ms. Deal.
Limited call, meaning he doesn't get a call on Saturday night saying, come look at this x-ray.
He's only on call about once a month.
Every fifth day.
Oh,
I could have to go into the hospital on those days. I rearrange them away from my parenting time.
okay. I'll have to see how that math works, because every 5th day, it seems like eventually it would land on parenting time.
Week, and I can change it. It's called, we just call it Q5, but it's every 5th week, and the weekdays and the weekends are separate blocks. So I can move a weekend without moving a week.
Mhm.
And then same with the week.
But I'm confused. I heard you say every fifth day, and then I heard you say every fifth week. Which is it?
There are blocks of weekends and weekdays, and they are, I have to do 1 out of 5, but I can rearrange them.
Okay. I'm still trying to follow this. Are you called in once a month? To me, that would be every 5 weeks. Or are you called in once a week? That would be every 5 days.
Once a week.
Once a week. Okay. But the way you are able to engineer that, it rarely, if ever, collides with your parenting days.
Yes, sir.
Got it.
Ms. Deal is an ER physician and works overnights, Sunday, Monday, and Tuesday with small variations. You went over the procedural history. Mr. Deal's current child support is $4,400 base child support a month. 50% of the rate of the nanny, which is $1,828. He pays the $1,828 whether the full expense of the nanny is incurred. There was a cost for daycare, but their youngest is now in school. He also pays 80% of medical, 50% of extracurriculars, up to $2,500 per child per year, and 50% of summer camp despite having a full-time nanny. There's a double there. Mr. Deal has paid $140,000 in child support in a 6-month period under the 2024 modified order. Of significance, Your Honor, and who we are hoping to have as a witness is the nanny, Melanie Goldie.
Who has a lawyer?
Yes.
Okay. Is there something I need to know about what's going on with the parents? Is someone suing her or?
There's absolutely no conduct claims and no one is suing Ms. Goldie.
Okay.
It's specifically about her hours worked and her compensation.
Okay.
Your Honor, if I may, she was deposed, so she had a lawyer simply to represent her during the deposition.
Okay.
And it's a colleague, both of mine and Ms. Hanrahan Freitag. We all used to work in the same law firm, actually.
Mr. Collard.
Small world. Okay.
Ms. Goldie has been employed by Ms. Deal since 2023. She's compensated at the exceptional rate of $850 per week every week for a monthly income of $3,698. What makes the rate particularly exceptional is Ms. Goldie works about 20 to 25 hours per week, which is an effective rate of $42 an hour. Ms. Goldie shared with us that her typical rate for services is $20 to $25 per hour for work outside of Ms. Deal's home. So a $42 an hour rate is very high. While Ms. Deal certainly has a need for work-related childcare, it's limited by the parenting plan schedule. The cost should be nowhere near $850 per week. You will hear that Ms. Goldie's rate is so that she can be available. That is her weekly rate. It's $850 whether you use 10 hours or 40 hours. We don't believe that to be true. Ms. Goldie has outside work.
Which part do you believe to be untrue? That she gets paid $850 a week or that she is effectively on call?
That she is effectively on call. The records will show she is consistently paid $850 per week.
Okay. What kind of evidence are you forecasting would be proof that she's not on call, that she wouldn't drop another situation to assist Ms. Deal if the need arose?
Her own testimony that she does conduct the other work. She will say that she prioritizes Ms. Deal. It's also Ms. Deal's testimony that she uses Ms. Goldie about 20 to 25 hours per week.
Okay.
A little about the parenting plan schedule. Mr. Deal has the children every other weekend, Friday and Saturday, and each and every week, Sunday and Monday, overnight to accommodate mom's work. That means Tuesday overnights are when mom needs childcare. I'd be remiss if I didn't say Mr. Deal would love to have the kids with him, but absent that, childcare coverage would just be for that Tuesday.
So every other Friday, Saturday, every Sunday, Monday.
Correct.
Okay. But not Tuesday.
But not Tuesday.
All right.
at a 12-hour overnight at $20 per hour. A more reasonable cost for childcare would be $260 per week. Additionally, Mr. Deal incurs his own nanny expense at $1,500 per month to transport the children before and after school. We are asking that Ms. Deal, of course, be able to choose the childcare she's most comfortable with, but the work-related childcare, the reasonable work-related childcare expense be reduced significantly to correlate to her actual work-related childcare at a reasonable rate. We ask that work-related childcare be handled outside of the worksheet as it fluctuates, so that there isn't an amount that's inserted and then a different amount of time that the nanny is used.
Why would you say that work-related childcare fluctuates if it would just be Tuesday night?
It wouldn't. Then it would be an inclusion in the child support worksheet. If there's an amount above that for additional time, right now the nanny is used occasionally for time that isn't related to work. We would
Okay.
not want to compensate for that.
But what's in the worksheet right now is the full $850 a week time, whatever the monthly version of that would be?
Correct, Your Honor.
Okay.
With the inclusions and Mr. Deal is comfortable continuing paying 50% of extracurriculars at $2,500 per year per child, continuing to share health insurance expenses outside of the premium at 80/20. And we would ask that child support reduce to $2,113 plus a reasonable amount for work-related childcare. If it gets included in the worksheet, it'll obviously increase that amount.
And the 2113 is what the worksheet would spit out if it reflected the 170-ish days rather than the 117.
Correct, although the 117 wasn't considered in the 2024 order. The child support addendum states how many overnights there are, but no parenting time deviation was included.
Okay. I guess it wasn't mandated back then anyway.
Correct.
Okay.
Thank you, Your Honor.
You're welcome. Ms. McCormick, do you want to say something now or wait till petitioner rests?
I'd prefer to do it now, Your Honor, if that's okay with the court.
It's 100% up to you.
Thank you, Judge. Typically, I do it this way. I think most of us do. Good morning, Your Honor. Thank you for joining us on the family law bench. I'm going to try to be limited in the opening because a lot of our contentions were already set forth in the pretrial order. We do that for a purpose. Judge Eaton has told me to not do long openings if I give him a consolidated pretrial order. The evidence will show, and I think what will be atypical for Your Honor is that there are a lot of areas of factual consensus in this particular case. For example, you will see that the parties' respective incomes are not in dispute on both versions of the child support worksheets. We are operating with the same income level. Those are the incomes reflected on the parties' respective financial affidavits. So there is not going to be a factual dispute there. Both of those versions of the child support worksheets demonstrate that the parties' incomes have both increased since the time of the 2024 modification. And as I know the court understands, in order to modify Mr. Deal's child support, this court has to find that there's been a change in either party's income or financial circumstances, or a change in the needs of the children. And we will respectfully submit as part of our argument in this case that neither one of those standards have been met, and that the same, the incomes have increased since the time of the 2024 modification order, and that the child care costs for Ms. Goldie were both known and understood to exist and remain at the same level as they were, as was the case in 2024.
The change in income that he demonstrated would be a material decrease?
It could, Your Honor, be my client's increase in income that could trigger it. So if her income...
Okay, the recipient, if the recipient's income went up or the payors went down, that would be a basis to reevaluate the equity and reasonableness of what had been ordered.
Correct, Your Honor. And we do not dispute that my client's income has gone up. I think both parties' income has gone up approximately $3,000 a month each, but that given the disparity between Mr. Deal's income and Ms. Deal's income, that doesn't make a meaningful difference.
Okay.
You will also see that both sides have included 173 days as the number of parenting time days for Mr. Deal in Schedule C. And you will see that both sides have included the same amount that my client pays for healthcare and vision coverage for the kids in Schedule D.
Why wouldn't this shift to 173 days from 117? Why wouldn't that be a reason to modify? In other words, run the spreadsheet again and see what number comes out.
Simply put, Your Honor, because his parenting time has not changed. He knew what the parenting time order said in 2024, and he agreed to this amount of child support in light of that parenting time schedule. It gets into a bit of a statutory construction issue, Your Honor, because he is saying that he should be able to get his foot in the door in contravention of the 2-year bar because he exercised more time than was set forth in the order. Nothing in the statute says which order you're supposed to look at to figure out what that means. We would respectfully submit that as a matter of common sense, it's the parenting time order. You have to look and see how much time were you exercising or agreeing to exercise in 2024, and are you in fact exercising more time than was under that schedule? And we believe the evidence will show that Mr. Deal is exercising exactly what he agreed to. And at the time in 2024, knowing how many overnights he was going to have with the parenting time adjustment, then in effect, although not yet mandatory, he agreed to this child support amount.
I want to make sure I follow you in two ways. One, does the parenting plan from 24 say 170 days or 117?
It is silent, Your Honor.
It's silent. Okay. So he didn't agree to a particular number of days. He agreed to
the schedule that he knew he was going to have, Your Honor. And I think it's worth teasing.
And was that I'm sorry to
Sure.
override, but is it what I heard about, which is the every other weekend, Friday, Saturday, and then every Sunday and Monday?
Correct, Your Honor.
That's in the parenting plan.
That's in the parenting plan.
Does that add up to 173?
I think it adds up more to like 177 we've brought, but yes.
But it's in that direction.
Yes, Your Honor.
Where does
Yeah.
the 117 come from?
It was in the child support addendum. We respectfully believe that it was a scrivener's error.
Okay. But it's in the addendum. The parenting plan doesn't give one a number, but one can calculate that number by figuring out how many Friday, Saturdays are there in the year, and then, or I guess every other, and then how many Sunday, Mondays are there in a year? And you're saying that gets you into the 170s, whether it's 171 or 177, it's in the realm of what, in fact, Mr. Deal is doing now.
Correct.
Which is what he agreed to.
Back then.
Okay.
Yes, Your Honor.
Understood.
Just as a matter of procedure, Judge, just quickly, you're correct in remembering that there was a DeKalb modification filed in 2024, but it was consolidated. What happened back then, I assume this is based on venue law. Mrs. Deal had initiated an action in DeKalb County. Mr. Deal initiated one in Fulton, and they were consolidated.
Okay.
And so the last order was, in fact, a Fulton County order that was entered in September of 2024.
Okay.
So, Your Honor, as you've already heard, there's two main disagreements here. The first is whether or not Mr. Deal is exercising different parenting time, or that somehow the difference between the 117 in the child support addendum and the actual 170-something nights that he agreed to exercise in 2024 and that he has exercised, whether or not that can be a change of circumstances that this court can take into consideration. We respectfully submit that it should not be. And then the second issue is whether or not my client's nanny childcare figure should be included in the calculation of child support. And again, our contention is that the answer to that question should also be yes. We will show, Your Honor, that Mr. Deal, with the benefit of counsel, agreed to the number of meaning he agreed to the parenting plan as well as the child support amount back in 2024. Whether or not my client's longstanding nanny cost should continue, the evidence will show that that cost was specifically referenced in the 2024 child support addendum. And the evidence will show that there was a specific acknowledgement by both sides that Ms. Melanie Goldie, that's the name of the nanny, would continue to be employed by my client. Also implicit, Your Honor, in Mr. Deal agreeing to the 2024 child support addendum was his acknowledgement that what he was agreeing to serves his children's best interests. Because what the court has to do, and I know Your Honor knows this, in considering a child support amount, one of the prime factors to be taken into consideration is the children's best interest. That's effectively the guiding principle of most family law in Georgia. So consequently, we are going to be asking that my client's nanny costs should be included in the child support worksheet. To the extent that Mr. Deal wishes to have his $1,500 a month that he pays for a nanny in his household in the child support worksheet, we have no problem with that, Your Honor. We are going to be submitting 2 different versions of child support worksheets to the court, one in which my client's nanny costs are included, and that's the only thing, plus the health insurance, the dental insurance, and the incomes. And then we have another version where we include the $1,500 a month for Mr. Deal in the child support worksheet. Both of them to reach the amount, I think Your Honor has already understood this, but what Mr. Deal is supposed to be paying my client, I believe it's on the first of each month, is $6,228. That's $4,440 plus $1,828 for the nanny costs. We respectfully submit that that amount should stay in place, and as a result, the child support worksheets, both of our versions that we're submitting to the court, have an upward income deviation to reach the $6,228 number. As a point of clarification, Your Honor, whether or not the court deems fit to change any aspect of the child support arrangement, we would be asking as a clarification that Mr. Deal be required to pay my client any direct child support amount by ACH recurring transfer. We have not filed a contempt about his failure to pay child support on time because he is, as we stand before the court today, current in all of his obligations. But my client, if the court's willing to entertain a brief bit of testimony about that, my client will tell the court that he has a history of not paying on time and that he is not, when his direct child support amount was supposed to include the cost of the nanny, he would elect not to do that and would just pay her the $4,440 a month, and then they would make separate arrangements for the payment of the nanny costs. So as to streamline this between the parties, we would prefer that. And
it's not a concern that he was paying in Bitcoin or through Zelle. It's that he was breaking the 2 pieces apart, and maybe according to your client, there was a delay in paying the nanny piece of the total $6,000.
There actually, I don't believe was a delay in paying the nanny piece. There was a delay in paying the primary child support amount.
Oh, okay. But this request for the ACH recurring transfer wasn't so much the channel through which he's moving the money is problematic. It was the timing of the money flowing through a channel.
Correct, Judge. I mean, just if it was an automatic recurring payment,
right.
Yes, that's our preference. It's more about the automatic aspect of it than anything else.
Okay. All right.
And then lastly, Your Honor, just briefly, we are asking that my client be awarded the entirety of her attorney's fees pursuant to 19-615 K5. And in the alternative, we've also asked for an award of fees pursuant to 9-15-14. I think a smaller allocation of fees is related to that based upon Mr. Deal improperly seeking to put his foot in the door prior to the 2-year bar.
On that topic, not about fees, but one of the arguments you made is that really we shouldn't be discussing this right now because Mr. Deal agreed to this number of days, nights through the parenting plan, and maybe there's not even the jurisdictional threshold of was there a meaningful change in income. Both parties have gone up, but your client's hasn't gone up so much more that there is a different ratio, if you will, and there's not a change in the kid's needs. But a ruling on that ground saying there's nothing to see here, doesn't that just do what I thought you wanted to avoid, which is kick the can to 1 month from now and then it would have been 2 years? Or there's still, those hurdles have to be cleared. You could be 5 years, and if there hasn't been a meaningful change in income or a change in the children's needs, you're knocking on a door that's not opening.
Well, Your Honor, I think both apply, but if I may, the reason we're asking you to adjudicate on the merits today is that if the court undertakes that task, then a new 2-year bar starts to be in place. And so it's for that reason that we're asking for an adjudication on the merits. The doorway always requires the change of circumstances in the income or financial circumstances or the needs of the children. But I believe that the public policy in Georgia to prevent the type of litigiousness that I respectfully submit has been demonstrated in this case is to make sure that you have a 2-year bar unless there's an involuntary loss of income or exercising of significantly more parenting time than was anticipated.
Got it. And it's that second one that Mr. Deal is relying, that second prong.
Correct.
And you're pushing back and saying, what's the surprise here? It's in the parenting plan.
Correct.
Okay, understood. Thank you.
Thank you.
All right.
Seek to call Melanie Gold.
Okay. You think she's arrived? You could yell loudly and see if she hears you.
To the witness stand right by the bed.
Hello, Ms. Goldie.
I do.
You have to see and just yourself. There's an edge here in your front.
Yeah.
You, for the record, state your full name, spell the first and last.
Melanie Goldie, MELANIE GOLDEY.
If you
Ms. Goldie, I'm gonna need you with that chair that doesn't have wheels to scooch forward because you're soft-spoken, at least you're using your indoor voice. I need you to be closer to the microphone. That way the court reporter and the person furthest from you, which is probably Ms. Deal, can hear you, okay?
Is that better?
It's a little better. All right.
Can I approach you with a binder of exhibits? They're not all for you.
Okay.
Can you identify what's been marked as Exhibit 8?
It would appear to be my employment contract.
Your original or your subsequent?
My original.
Is it your signature that appears on the last page?
Yes.
Move to admit plaintiff's 8.
Any objection to plaintiff's 8?
No, Your Honor.
It's admitted.
If you flip to number 9, the very next exhibit. Can you identify this document?
It appears to be my amended employment contract.
All right. And is it your signature, your electronic signature on the second page?
Yes.
What is the date of the contract? It's on the first page near the top.
8/8/25.
Move to admit plaintiff's 9.
No objection, Your Honor.
All right, 9 is admitted as well.
If you will skip to exhibit 12. Do you recognize this document?
Yeah, it's a section of my bank statement showing my pay.
Move to admit plaintiff's 12.
No objection, Your Honor.
Admitted.
Now I'm going to ask you some questions about those. Oh, and exhibit 10 is quite bulky. Sorry to go out of order. Can you identify this document?
It looks like a printout of my Google Calendar that I share for my work schedule with Anna Kate.
And you call Ms. Deal Anna Kate?
Yes.
Is this an accurate reflection of the shift she worked?
Probably not 100%, but probably pretty accurate.
And do you indicate on here when you will not be available?
I try to.
Simply because it's a little more comfortable here, may I continue to question from here? Or
That's
is it-
fine with me. You are audible. As the key, you can be in the back of the courtroom as long as we can hear you. That works.
If you will look at tab 8.
Did you want to tender exhibit 10?
I did, thank you, Your Honor.
Any objection to plaintiff's 10?
No, Your Honor.
Petitioner's 10? It's admitted.
Looking at petitioner's 8. How many hours did it anticipate you working?
Um, I don't even see a total of hours. We always talked in shifts.
It says work hours, 36 shifts. Could that mean 36 hours?
No,
Oh, it's 36 shifts per quarter.
correct.
How long is a shift?
It depends. It started out as overnight.
It says primary hours will be 7 PM until completion of drop-off, handoff of children the following morning. When would that typically be?
Around 8 a.m.
Okay, so that sounds like 11-hour shift.
And what do you indicate? And you're paid $8.50 a week for 36 hours, 12,
36 shifts per
13
quarter.
hours.
Yeah.
1326.
Well, each shift is about 11 hours, so the number of hours a week is going to be some multiple of 11. How many shifts if a shift is, I know it wasn't always this way, but from 7 PM to 8 AM, I say 11 hours, that's 13 hours. 13 hours, how many shifts did you work in a typical week?
3 or 4. It would change depending on Anna Kate's work schedule.
Okay.
Ms. Golding, you might be able to move the microphone towards you a little bit.
It actually, you have to lean into it. It moves up and down. It doesn't move forward and back.
Scooch a little bit. The chair doesn't cooperate very well.
Doing a little bit of math.
Yeah.
13-hour shift times 3 times a week is about 39 hours a week. And your rate is $8.50. That comes out to about $22 an hour, correct?
Sure.
And you indicated your overtime pay rate was $25 per hour.
Yes.
What triggers overtime?
A date night, a special occurrence, maybe a doctor's appointment, something that she might need extra.
So outside the shifts.
Correct.
In other words, if drop off ended up being at 8:30 instead of 8 AM, that's not overtime.
No, and we never tracked it that closely.
Okay, it would be, hey, it's a Wednesday night. Could you come be with the kids? That's an overtime.
Absolutely.
That's not part of the 850. That would be the $25 an hour for however long the date. It's going to shorten my date. Okay.
And you work this shift until Mr. and Ms. Deal, we're calling them Mr. and Ms. Deal to distinguish them, modified their schedule in 2024.
Correct.
All right. And how did your hours change in 2024?
Then it went to picking up the kids from school, from Mr. Deal's house and dropping them off. And it's hard to, it's shifted again since then. So it became more covering during the day, especially during the summer, so that Anna Kate could sleep from work, covering from when the kids would wake up in the morning till she had adequate sleep time, or if she had an appointment, coming home from there. It's always shifted quite a bit, so it's hard to say exactly what a normal schedule would be. Past that first year, we went pretty hard off the schedule.
So this 13-hour shifts 3 or 4 times a week, that's yesteryear. You don't do that anymore.
Not at all.
Okay. What would you say the routine is now, insofar as there's a routine?
So I pick the kids up and drop them off at school every day, Monday through Thursday. And I stay overnight on Tuesdays. So I pick them up from Mr. Deal's house on Monday and Tuesday mornings, and I drop them off. And then I pick them up from school as well in the afternoons and get them home. And then I stay overnight on Tuesdays.
If we're going to have to break that down in a minute, but you mentioned like doing something on a Thursday. My understanding, informally, is that Ms. Deal isn't doing an overnight that would impact a Thursday.
No, this is so that she can maintain her sleep schedule because her sleep schedule is overnight. So we shifted it a little bit since
Got it.
she was staying up till 6 a.m. most days and then having to turn around and do a 180 on Wednesday, Thursday, Friday.
Got it.
So we shifted it so that she could sleep in a little bit and I would take over drop-offs and pickups entirely.
Okay. Now I see why you would be there on those days. So it's work related in the sense that it allows Ms. Deal to not have, I'm awake overnight some days a week, and then I'm awake in the middle of the day on other days a week.
Correct.
And be constantly a zombie.
Yeah.
Okay, so if you could repeat for me, you pick the kids up from Mr. Deal.
Monday and Tuesday, and then Wednesday and Thursday, I picked them up from Miss Deal's house, Ms. Deal's,
And take them,
to school.
to school, not to your place.
No.
They're all in some form of school now.
Yes, they go to the same school.
Okay, what school is that?
Herds Ferry Elementary.
Okay. And how many hours, if we add up all the time? I guess when they're in school, you're not working for Ms. Deal, but how many hours does this pick up and what you're
It's
describing?
hard to tell. So I picked them up from Mr. Deal's house Monday and Tuesday mornings at 6:45, and I'm usually home by 8:30.
Home to your place?
Correct.
So maybe 2 hours-ish of work on Monday and Tuesday.
And then I'm in Carline by in between 1:30 and 2 p.m. And then that gets a little dodgy because sometimes I stay for a few hours and sometimes I drop them off and run, depending on what I have going on that afternoon. So
Okay.
it could be anywhere from another 3 hours of work to 6 hours of work.
Okay.
And then I stay overnight on Tuesdays still.
Do you, and you don't need to keep track of your hours because it's a flat rate.
Correct. And we've both talked about we prefer it that way.
Okay.
It's just easier.
All right. Well, then I'm gonna need to parse it out then. So
Yeah.
Monday and Tuesday, 6:45 to what I'm gonna call 8:30 is about 2 hours in the morning.
Correct.
And then on Monday and Tuesday, you pick them up from school.
Monday through Thursday. Yeah.
Okay. Because Mr. Deal picks them up on Friday from school.
Miss Deal does.
She picks them up on Friday. Why not Thursday?
Same thing, just so she can maintain a regular schedule.
So why Friday?
Mostly for me.
Okay.
I host karaoke on Fridays, so it's a little easier between the jobs that I work. I also pick another set of children up in the afternoon. They're older, so they get off a little later.
So Monday, Tuesday are the only days where you've got the early morning piece.
No, Monday through Thursday, it's just Monday and Tuesday, I pick them up from Mr. Deal's house. Wednesday and Thursday, I pick them up from Miss Deal's house. And then I also get them ready for school on Wednesday and Thursday morning.
Got
So I'm
it.
there a little earlier. I get them up, get them dressed, breakfast, and then out the door. I don't just pick them up.
So Wednesday, Thursday, what's the morning hours?
I show up at 6 a.m. and I get the kids up.
And then it's
ready.
still to about 8:30-ish, depending on, okay. 2.5 hours. And then the afternoons, Monday through Thursday, this is the 1:30. When do you hit the carpool line?
Yeah, about 1:30, in between 1:30 and 2.
That's Monday through Thursday. So 1:30, and then this is where the big variable is.
Yeah.
Sometimes you might be around only until,
Sometimes I drop them off and run. So I
Okay.
would drop them off probably around 3, in between 3 and 3:30, depending on traffic,
okay. And other times you might stay as late as,
till after dinner, 6, 7. And then
okay,
if I have my overnight, sometimes I'll just stay
okay. And your overnight is which night?
Tuesday.
And why that night as opposed to any other night?
Anna Kate has work.
Oh, right. Okay. So you would pick them up at 1:30 on a Tuesday and then you'd be there really till 8:30, not necessarily at home, but with the kids until kind of 8:30-ish Wednesday morning when you drop them off at school.
Correct.
Okay. All right. Sorry to hijack that. I just am going to want to get some hours. And just so you know where my thoughts are, the original arrangement where it was, let's call it 40 hours a week, and you did some math and said it was about $22 an hour. That didn't seem like a bad rate. That is the wrong word. That didn't seem like a exceedingly high rate. And so I'm going to be thinking about how one converts the hours that Ms. Goldie just described she's doing now, because that's what we're focused on, not last year, but now, and what that hourly rate is. Because $8.50 a week for 1 hour, that's a real high hourly rate. But $8.50 a week for 85 hours, that's a really low rate. We're somewhere in between 1 and 85.
When did you start doing Wednesday and Thursday mornings with the kids at Ms. Deeds?
When school started this year.
So about 3 weeks ago.
Yes, but before that, I see the schedule changed so much. Before that, I was with them in the mornings, Monday, Tuesday, Wednesday mornings from about 7 or 8 in the morning until 2 in the afternoon or 3 in the afternoon.
Because that was the summer schedule.
Correct.
And Ms. Deal was needing to sleep. And so you were there, but if they're at school, she can sleep and you don't need to be there.
Correct.
Got it. Did you fulfill an additional role of you're cleaning the house or you're walking dogs or you and the kids? That's your situation.
Do little things around the house, dishes. Yeah, absolutely help the dogs.
Okay.
Stuff like that. Just, part of the family, trying to help out.
Okay.
Staying focused on now, but the last school year, you didn't do Wednesday and Thursday mornings with the kids.
No.
That's new for this school year.
Yes.
When I deposed you, school hadn't started yet. You hadn't started those hours.
Right.
Last school year, Ms. Deal did mornings with the kids on Wednesday and Thursday.
Yes.
Looking at Exhibit 9. Where does it indicate you'll be doing Wednesday and Thursday?
I don't think this one does it? We hadn't had a new amended contract for these hours. It's something we discussed. We actually just ended a trial period. We talked about doing a trial period and then making this more permanent if it worked out, which it has.
The trial period, meaning the scenario you and I just worked through with the Monday through Thursdays in the afternoon, Wednesday, Thursday in the morning, which is different from petitioner's 9. That's what you were sort of doing the test kitchen on to see
Yes.
how it worked.
Yeah.
And
It's working good.
Okay.
I think so. I think Anna Kate's already told me she's a lot happier being able to actually get some sleep.
okay.
Looking at page 2 of Exhibit 9, it doesn't indicate that you'll work Thursday and Friday mornings, correct? For a summer schedule?
No. But again,
You're looking at the wrong exhibit.
Yeah. Exhibit 9?
9, that's 8.
Yep.
Second page.
The summer schedule.
No, it doesn't. But again, I feel like the schedule on the contract has never been strict.
The children attend summer camps during the summer,
Yes.
and your rate doesn't change during the summer.
No, we've always been happy to keep it flexible.
The summer camps, are they sleepaway summer camps?
No.
So some of this same dynamic that we just worked through where you show up in the morning to get them dressed and ready and fed, and then you're taking them to summer camp. It would happen in the summer, just like it happens during the school year.
Correct. And sometimes I would hang out with them at swim meet. I would be there the entire time as well.
Okay. Because everything was local and I'm gonna call it day-based, was the routine all that different from you've just described how you are supporting Ms. Deal for this few weeks of the school year so far?
No, I would say, if anything, I worked more hours then because I was with them more.
Tell me about the work you do outside of Ms. Deal.
I have another family that I work for. They're just older children, and I'm basically a glorified chauffeur, and I pick them up and get them home or to extracurricular activities in the afternoons. That schedule is very, very, very flexible and varied. And then I'm also a karaoke DJ.
Where do you do that?
On Thursdays at Johnny's Pizza Midtown and Fridays at Outrun Brewery in Stone Mountain. And then sometimes other places. I work for a larger umbrella of karaoke hosts, so I fill in as necessary if I have free time.
The other family you work for, that can be Monday through Thursday or Monday through Wednesday?
Monday through Friday.
What if it conflicts with the schedule for the deal kids?
We work it out. It rarely does. Because their pickups tend to be later in the evening. They're older children and they have volleyball and band and theater.
What is the rate you charge for that?
It's also a flat rate. Their father pays me $25 an hour, but he pays me regardless of whether I work that shift or not. So he pays me a salary essentially. On top of that, I get a gas stipend and reimbursements for snacks for the kids if we stop at Starbucks or whatever.
What is your stipend?
$45 a week.
And what is your salary?
500.
Do you know how many hours on average you work for the other family?
It's hard. I can. It really, there's no average there because some weeks I'm picking up one girl one day. Some days I'm picking up one girl, driving her home, going back to school, picking up the other girl, driving her home, and doing that 3 days a week. So it's on average from 3 to 40 hours a week.
How are you doing that if you are picking the deal kids up at 1:30 and that could extend all the way through dinner if you're making dinner? Do those other kids just have to wait till you're done?
So that's where this Google Calendar comes in and we just work it out. So the earliest the other girls get out is 3:40. Those are the days that I would drop the kids off and run.
Got
literally
it.
run.
That would not be a let's stay for dinner day at the deal household.
Right.
Okay.
And then sometimes they don't get out until 5, 7 o'clock at night.
So you know their schedule, which lets you know I have flexibility to stay longer to support Ms. Deal's household and be with the kids.
Correct.
Okay.
Do you ever work Thursday nights for Ms. Deal?
I have, I'm sure at some point, yes.
Is it rare?
Probably, yeah, I think so.
Fridays are rare.
Yes. Evenings, yes.
Just to clarify, on Mondays, you drop the children back at Kyle's at Mr. Deal's?
No, I bring them home. I bring them to Miss Steele's house
And when do they transition to Mr. Deal's?
at 6 p.m.
Do you provide that transition?
No.
Have you been asked?
Yes, initially, when we first did the addendum. I think that was kind of on the table of discussions of how the schedule was going to change.
On Tuesdays, you get the children from school and you may stay overnight into Wednesday.
Often, yes.
Okay, and then you're with them Wednesday and Thursday morning to get to school.
Yes.
And then with them again in the afternoon, dropping them at home either right at 3 or continuing till 6,
Yes.
dependent on the schedule of your other families and your other work.
Correct.
So I guess Tuesday nights, you can't ever pick up the other kids because you are doing an overnight at Ms. Deal's.
Sometimes I still can. Again, this is newer, this whole thing. But the way we've kind of worked it out is that we just communicate. And on those days, so if I need to go grab those other girls, I can drop them off and then I just need to be back by 7 p.m.
Got it. So Ms. Deal would be with her kids, then you'd return.
Correct.
Okay.
Nothing further.
Ms. McCormick, do you have any questions for Ms. Goldie?
Do you please and thank you. Ms. Goldie, how long have you been paid the flat rate of $850 a week by Ms. Deal and Mr. Deal through the child support arrangement?
Since I took over full time before,
Which was when?
when we started the contract, the original contract,
And could you remind the court when that was?
October 23.
Okay, so fair to say that you've had that rate in effect for almost 3 years now?
Yes.
Okay, and could you tell His Honor what went into calculating your flat rate of $850 a week in your mind?
Sure. A combination of me needing a steady paycheck, keeping everything as easy as possible, flexible on both sides, and with regards to my extensive childcare experience and early childhood education experience, educational arts experience, and budgeting, just really keeping it easy, I think, on both sides.
And do you have some familiarity with the market that exists for childcare providers like you?
Absolutely.
And do you consider the $850 a week flat rate to be consistent with the market?
Yes.
Why?
Good help is hard to find. Someone with my experience, especially, and someone who spends as much time with the kids as I do. It's not just, I'm not a glorified chauffeur at the Deal House. I mean, I am involved in their lives.
You're contrasting your role in the Deal household with the, I'm going to say mystery family. You know, the name doesn't matter, but that other family.
Yes.
You use that term glorified chauffeur. You're embracing it for those young ladies. You love them, but you just drive them places.
Correct.
Get out of the car, got to go.
They still call me their nanny, but I joke with them that I'm just their chauffeur.
Okay.
And I believe you stated that your flat rate for that family is $500 a week versus the $850 a week?
Correct.
Okay. And in your mind, when you were first coming up with the $850 a week flat rate 3 years ago, was there a certain number of hours baked into that number?
No, it was a yearly salary.
And has either party in this courtroom ever asked you to renegotiate that rate?
Not personally.
When you say not personally, like they've called your agent or?
No, well, I mean, just me being here in court.
Okay.
And in what way, and this is again, just asking you as a layperson, Ms. Goldie, it's fair to say that there are times that you're working and providing childcare for the Deal family that my client is not working at the ER. Is that right?
Yes.
But do you nevertheless think that some of your work done for this family when Ms. Deal is not at the ER supports her work at the ER?
Absolutely.
How so?
So that she can maintain a regular sleep schedule and also have a human life, go to doctor's appointments, do things. She also coordinates things with the kids where maybe she needs to take one child and I can be there and support because her schedule is bonkers.
Have you ever seen her catch up on charting while you're providing childcare for the children?
Absolutely. Sometimes she's there at the house just trying to work in the office while I take them out just so that she can focus on work.
And I believe you testified at your deposition about attending birthday parties and dance recitals for the Deal children. Are you on the clock when you're attending those events or off the clock?
No. I'm there because they want me to be there and I want to be there.
Can you describe your relationship with the Deal children as it's evolved over this 3-year period to His Honor?
I mean, I love these kids. I feel like part of the family for sure. They love me. They tell me they love me on a daily basis. They tell me they want me at their birthday parties. We talk about their dreams, their day-to-day schedules. I know their friends' names. I know their friends' parents' names. I definitely feel like part of the family, and that's nice. It's nice to have a working relationship that also feels like a family relationship.
And how old was Lily, the youngest, when you first started working for the Deal family?
Oh, she was
How old is she now?
5.
And let me ask you one other question. This past summer, were the children enrolled in any summer camps?
Yeah,
Okay.
some stuff here and there, but I spent a lot of time with them this summer for sure.
Okay. Compared to previous summers, did you spend more time with them this past summer?
I think so.
That's all I have at the moment, Your Honor.
Any redirect?
No.
Okay. Ms. Goldie, thank you for your time.
Okay.
You
Am I
are-
supposed to go?
Does she need to stick around?
No, she does not. You're free to go.
All right, love the nail polish. You are free to go. All right, Ms. Hanrahan Freitag, next witness.
Call Mr. Kyle, Dr. Kyle Deal.
All right.
Yes, sir. Yes, sir. To raise your hand. You start from this one, that, what you said. Yes, sir. I can be with, position, chair, what you need. But it's almost like. What state your full name, your last name.
Adam Kyle Deal, ADAMKYLEDEAL.
If you will look at what's marked as 1 in the binder. Do you recognize this document?
Yes,
What is it?
the domestic relations financial affidavit.
And is it true and accurate to the best of your knowledge?
Yes,
Move to admit plaintiff's one.
No objection, Your Honor.
One is admitted.
Looking at page 1, what is your gross monthly income?
$114,721.
Is that more or less than your monthly income in 2024?
It's actually slightly less, but it's pretty darn close. Oh, 2024?
Mhm.
I think that it's pretty close.
If you will look at tab 4 and flip to the child support addendum. It's a couple pages in.
I'm sorry, tab 4 now exhibit.
Exhibit 4. It's behind tab 4. I'll be better about calling it exhibit.
No worries, thank you.
Binder item 4.
Yes.
Yeah.
Okay,
And if you go a few pages in, there's the child support addendum. They're not numbered sequentially, but it's in there. You'll find it.
yes, sir, I found it.
Okay.
Page 1, what was your gross income in paragraph 1?
111,181.
So you've had a slight increase in income.
Yes, ma'am.
That's monthly income.
Correct.
Okay.
What are you asking the court to do today?
To recalculate the child support worksheet and to remove the non-work related childcare from the child support worksheet.
Do you have an opinion on what work-related childcare is necessary for Ms. Deal to perform her work?
Before we get to this, fair question. You're going to answer it. You're asking for two things. The second one, your lawyer was just about to ask you about. But the first one was you want child support recalculated, and that's because of the parenting time, or is there, I want to make sure I've got all the dimensions here.
Yes, sir.
Okay, to reflect the 170-ish rather than the 117.
Yes, sir.
Okay.
And then tell me about what you consider a reasonable work-related childcare.
When you're working, is work-related childcare or, with a buffer. That's, if I have to use childcare, then that's how I do it. An example is Melanie on Monday and Tuesday morning.
Melanie,
Goldie.
meaning Ms. Goldie. Okay, Melanie's fine. I just wanted to make sure, because I know you have a nanny as well, so I wasn't sure which one we're talking about.
And her name is Rose.
Okay, that's different.
Sometimes I'll have to leave before 7 a.m. So rather than trying to get the children to school really early, I think it's work related to get them to have her come at 6:45 and bring them to school. I've already left for work, or I'm about to leave for work right when they go out the door. So that, to me, that's work related. And that's it.
Let's talk a little about how you use your nanny, Rose. What is her rate?
Her rate is, I pay her $125 a day. So generally she works 3 hours. And I think that's like $40 an hour. Yeah, I think that's like $41 an hour
When do you use her?
on Sunday, Monday, and Friday afternoon.
Say that again. Sunday?
Afternoon, Monday afternoon, and Friday afternoon.
Okay.
Only for pickups, and it's to basically ensure that I'm 100% consistent about the timing of pickup from their mom.
Those 3 pickups, Sunday, Monday, and Friday, are from Ms. Deal, not from school.
Yes, sir, that's right.
Got it. And it's if you're not available, or even if you are, it's Rose who does the pickup?
It's not, if I'm available, I do the pickup.
Okay.
If I'm not, then it's Rose that does the pickup.
It's security for you. If you're stuck doing work, Rose is there to make it happen, as you said, consistently on time.
Yes, sir.
Okay.
Is Ms. Deal married
Yes,
and her spouse resides in the home?
yes,
You are engaged
yes,
and your fiance resides in the home.
she does.
Her name is Spencer Hewitt.
Yes, ma'am.
Does she provide childcare?
I don't know. If she does not, I think in the 4-ish years that I've known Spencer, I think she's been alone with my kids, maybe like an hour or two without me there. So I would say in terms of being like a childcare provider when I'm not there, no, she doesn't.
Can you spell her last name?
Hewett. But in terms of having a relationship with the kids, definitely, they see her every single day.
Does she work?
Yes, sir.
What does she do?
She's a medical device salesperson, sales rep.
I'm looking at Exhibit 5. Is this your proposed child support worksheet?
Just a moment. Yes,
You're asking the court to reduce your base child support to $2,113.
yes,
In addition to that, you would provide extracurriculars of $2,500 per month per child, $2,500 per year per child,
yes,
which is what is stated in the 2024 order.
that's right.
And what is your proposal for summer camp?
That we pay our own summer camp. Or if we can't do that, then we would split it. But I don't use summer camp when the children are with me during the summer. I get 3 weeks and we almost always go on a trip all 3 of the weeks. So it's irrelevant. The summer camp is not something that I typically use. But if I was to use it, I would pay for it myself. Sorry if I droned on there.
No, what I understand you saying is each parent should pay for his or her own summer camp. The weeks you have with the kids, you don't use summer camp. So there's nothing that Ms. Deal would need to contribute to. You manage that and you're taking the same view of the weeks that she has the kids. She could go on a trip with them, and if she chooses to work, she ought to pay for summer camp.
Yes, sir.
Okay. I mean, you still be paying child support. It's just, it's not in addition, you're paying for summer camp. And so I'm clear that extracurriculars, it's $2,500 per kid per year, not monthly.
Or
Okay.
not monthly, annually.
And how does does that somehow get paid? Is that in this worksheet? There's whatever that math would be. 2,500 divided by 12 times 3 is in here, or that's a separate stream?
It's a separate stream.
Okay.
And my next questions are related back to something Ms. McCormick shared. How do you pay what channel do you use to pay child support?
Currently through our Family Wizard.
Have you found limitations with our Family Wizard?
They have unpredictable, I can issue the payment, but it's unpredictable when it clears through their system and goes to Anna. And so,
Meaning you might pay, I'm making it up, but you might pay it on the 4th every month. And sometimes it gets to Ms. Deal on the 5th, sometimes on the 9th, but you're pressing whatever buttons you need to press at the same time each month, and you're getting different outcomes.
yes, sir.
Were you required, I know I keep stepping on you.
It's okay.
Were you required to pay child support that way? Or that's just what you and Ms. Deal agreed to?
I don't think I was absolutely required to, but I was required to put all communications through our Family Wizard. So, and Anna is required to put the billable items in our Family Wizard. So I thought it was most consistent to try to do it.
Sure. I just was curious because if you were mandated, then if I'm going to change it, I just have to enter an order saying, no, pay it this way rather than that way. But it just may have been a matter of convenience, but it's not functioning real well.
Did you find that there were caps with our Family Wizard?
$5,000.
And your monthly obligation exceeded that?
Right,
So you had to break it into 2 payments?
right.
And again, our Family Wizard wasn't always consistent transmitting that payment to Ms. D.
That's right.
Though you were consistent in payment.
Yes.
How, do you have a preference as to what channel you use going forward to pay support?
Our Family Wizard,
Why?
because it's an immutable ledger. If it gets approved through our Family Wizard, then it's in one consistent document. And in the past, things that I have paid, Anna has said in the past that I didn't pay things that I had in fact paid, and I had to show proof of it. Our Family Wizard takes care of all of that.
Does our Family Wizard document when you initiate the payment?
Yes, sir.
So we'd always be able to tell, hey, you did what you could do as of August 1. And the fact that it wasn't till August 5 that it made it to Ms. Deal, that's not a Mr. Deal issue. That's an Our Family Wizard issue. And people, if that's going to be the mechanism, are just going to need to understand that it isn't quite like Zelle where 2 seconds later it pops up in your account. Is that a?
Say it verbally.
Yeah, sorry. Yes, sir.
Okay.
Yes, sir.
You pay child support through the Our Family Wizard app?
Yes, ma'am.
You paid the reimbursement for work-related childcare expenses through the app?
Yes.
You pay your percentage of health care reimbursables through the app?
Yes.
You paid your percentage of summer camp through the app?
Yes.
The variable expenses are the ones you're saying it keeps a really good log.
Yes.
The consistent expenses are less of a concern.
Right.
If you'll flip to Exhibit 7.
Okay.
Can you tell me what this document is?
It's a list of my custody days from 24 to 26.
And how many overnights did you have with the kids?
About, should I read them or just,
No, go to the summary.
okay. 173,
Which is what percentage of the year?
47.4.
Did you understand this would be your parenting schedule in 2024?
Yeah, in general, yes, I understood. I didn't understand that it'd be 173 nights, but but my parenting schedule has been what I agreed to in 2024.
I want to make sure I follow that. I think we are saying the same thing that I extracted from Ms. McCormick, which is the parenting plan says that Mr. Deal will have the kids every Sunday, Monday night, and every other Friday, Saturday night. That's what you agreed to, but that parenting plan didn't add all that up.
Yes, sir.
But it turns out if you add all that up, it's about 173 days.
That's right.
So for last year, 2025, you were not required may be the wrong word because it's great to be with kids. You didn't exercise more parenting overnights than the parenting plan called you for. I mean, maybe one here or there, but in general, you were with the kids for overnights exactly as the parenting plan said.
Yes, sir.
Okay, which adds up to around 170. It's just, there's some other document somewhere where for whatever reason, someone put 117.
Yes, sir.
Okay,
Could I say one other thing?
please, yeah.
But the 173 nights is actually capped by Anna because I requested to take the kids on Tuesday night when she works, but she did not want me to. And also when Anna goes out of town to travel, I request to have the kids, but she does not let me have them during that time either. So in my opinion, it would be more than 173
Okay,
if I had
what you've asked for, but the parenting plan, which is the governing document,
Yes,
it's
sir.
not Ms. Deal who's the governing document. The parenting plan is that you absolutely get the kids the nights you and I talked about. And that gets us to the 173. I don't know if there's a right of first refusal in the parenting plan. I'm sure the lawyers will bring it up, but that's a concept that I don't know that anyone asked for, where when one parent is going to be out of town on that parent's parenting night, the other parent has a chance to say, then the kids are with me, not with a babysitter, not at friends' houses, but they're with me. Sounds like that's what you've asked for. But if it's not in the parenting plan, then Ms. Deal isn't not letting you see them. It's just, that's not what the parenting plan calls for. In the same way that if you and Ms. Hewitt were going to go out of town one night when you had the kids, Ms. Deal might say, hey, let them stay with me. And you could say no, and you're not violating any agreement.
Yes, sir.
Okay.
Understand.
Is there, since you're the attorney asking questions right now, Ms. Hanrahan Freitag, is there a right of first refusal? No. Okay. Did you write the parenting plan?
No.
Okay. They left out an important piece.
If I may ask Ms. McCormick, are you going, your child support worksheets have Mr. Deal's income at the 117? Is that what you're going to put forward?
I think they match.
They match. What I'm trying to exclude is going through his taxes and pay stubs.
Your Honor, I don't know that there's a need for that. If she wishes to perfect the record by entering some additional information, she may, but we are in agreement that for the purposes of the child support, that the parties' incomes are what is reflected in their financial affidavit.
Right. That's what I heard in Ms. McCormick's opening, that actually a whole lot of facts are agreed on. So, Ms. Hanrahan Freitag, if you want the record to include W-2s and tax returns, you certainly can admit those. It sounds like it will be without objection, and we'll go from there. I defer to you on that one, but it doesn't sound like there's going to be a fight. Oh, you actually made more. You're hiding some of your radiology income. The numbers are the numbers.
Thank you. Mr. Deal, can you flip to Exhibit 18?
I'm there.
Is your employer TriNet HR the third?
Yes, that's the company that manages our W-2 payments from Summit Radiology. But I work for Summit Radiology.
All right. This is a reflection of your 2025 W-2.
Yes.
Move to admit plaintiff's 18.
No objection, Your Honor.
Admitted.
If you'll skip to Exhibit 19. Is this a true and accurate reflection of your K1 from Summit Radiology?
Yes.
Move to admit plaintiff's 19.
No objection.
Also admitted.
Do you receive, if you'll skip to 20? You run a consulting business?
And it's not a consulting business. It's a software integration company, but I wish it was a software integration company, but it's really just, a lot of me sitting in front of my computer, but it's called CareBridge Systems.
And you took a small loss in 2025.
Yes,
This is a true and accurate reflection of your K1 for CareBridge.
yes.
Move to admit 20.
No objection?
Also admitted.
Why do you pay Rose a flat rate as opposed to hourly?
Because if she was to, you mean per day, right?
Yes.
Because it's the time, the hours may be unpredictable if it's, if she doesn't, like, for example, if she was to pick the kids up and then bring them to my house, but she was to get there at my house at 6:30, I'm going to let her go. And, and I'm not going to deduct the hour because I want her to be consistent. So I just pay her the same thing every day regardless, even if it's 3 hours or if it's 2 hours. And I don't want her to not be available in one of those times when, if like I got hung up at work or something and I was going to be super late or just a little late. So I wanted to kind of be an easy yes for her because it's just these random periods.
It sounds like it can cut both ways. Sometimes she works a little less, sometimes a little bit more, and you two have agreed on what is a healthy average.
Yes, sir.
Her hourly rate based on the daily rate is quite high. How do you justify the high expense?
If I'm at work, it's basically two things. I work at different hospitals. Sometimes it's quite far away, like Cartersville. And on those days, my commute in will be longer. And I can't always predict where necessarily I'm going to be on a specific day. They switch us around and everything. So reliability is huge. So I pay her for a little bit for reliability. And then the second is because Anna requires absolute consistency with the time. And so I need her to be absolutely consistent. So it's kind of a, my hope was, I picked the number my hope was it was a good enough pay that she would take it and always be there when I needed her.
If you paid her a more traditional $20 to $22 per hour, you would worry about the consistency and reliability.
Right. Nobody's going to take a 4-hour week for $22 an hour and be consistent because they'd have to get other work. I mean, I'm sure she has other work, but yeah.
And her monthly rate comes out to about $1,500.
That's right.
Until today, were you aware that Ms. Goldie was working Wednesday and Thursday mornings?
No.
Do you know if she was working Wednesday and Thursday in the past?
Yes. So I know that Melanie works all the days of the week, but I have no insight into when that is. So I didn't know that she works on Wednesday and Thursday morning until she said it.
Do you believe Ms. Goldie works times that are not work-related?
Yes.
Why?
I just heard her say it, And also, the kids tell me, not that I'm interrogating them, but they say, Melanie took us to, like, for example, this past Sunday.
Objection per se.
It is. You can't tell us what the kids say, just what you know.
Okay.
Well,
We'll just-
but he may know it because the kid said it. So to make it clear, just focus on, you were about to give some examples of things Ms. Goldie just said that you felt were not work-related child support. So I'm happy to hear your assessment of her testimony. You just can't then add, and I also know that she takes the kids to Six Flags, because if the only way you know that is because the kids tell you, really, we need to have the kids come in here, or someone should have asked Ms. Goldie about it, and no one did. So we'll stick to what your assessment when she was describing the different things she does. Okay, that's not work related. I'm interested in your perspective on that.
Melanie, I just heard Melanie say that she has a very flexible schedule, that they work it out, that Anna and she work out when she's going to work, that she sometimes works Wednesday and Thursday, that she sometimes does, that it's less Friday because she has another obligation. I heard her say she also works Saturday and Sunday when Anna does not work. So she, yes, I think that she works when Anna's not working.
On Monday and Tuesday mornings, the kids are with you.
Yes,
Who gets them ready for school?
me.
Do you believe Ms. Deal needs nanny care Wednesday and Thursday morning?
I don't know, but I don't believe it's work related. She may have a sleep schedule that she prefers, and I don't begrudge her that, but I don't think it's work related. I'm trying to answer it accurately. One other thing, if I could say, when I picked the children up the week before last on Sunday, I picked them up from Melanie. Anna Kate was out of town. She was not working. So another example of from my own experience.
No further questions reserved for redirect.
All right, give me 1 second, Ms. McCormick, and you can cross.
Ask you questions. Of course.
Okay.
Your Honor, I conferred with my opposing counsel. You will see this a lot in loosey-goosey family law world, but she is willing to let me go beyond the scope of her direct so that we can only have Mr. Deal on the stand one time, if that makes sense.
It does, and I don't think I put it in, I don't think I have a standing trial order for family, but in my civil standing trial order, I made very plain that had you, Ms. Hanrahan Freitag, called Ms. Deal, in your case, Ms. McCormick would be free to ask questions then and wouldn't waive the ability to call the person. So I am not focused on the scope of, I mean, I'll pay attention to scope of direct. If you start asking Mr. Deal about what he did in high school, that's not so germane. But if you want to cover everything now, I'll absorb it all now, and then he doesn't have to trek up to the stand a second time.
Yes, Your Honor, thank you. It's my preference. Sometimes courts prefer to do it the other way unless there's an agreement between counsel. So
Okay.
I appreciate it.
Sure.
All right, so good morning.
Morning.
And I'm going to refer to you, I apologize. I think both of you have earned your medical degrees, but it's easier to say Mr. and Ms. while you're in this, in the courtroom today. So I'm going to continue doing that. As you know, I'm Sarah McCormick. I'm the attorney for your ex-wife. It sounds to me, Mr. Deal, that You and my client are largely in alignment on how much you should pay a child care provider to be flexible and reliable. Do you agree with that?
I don't know.
Okay, so I heard you say about your nanny, Nanny Rose, that reliability is worth paying for. Did you just testify to that?
In that case, yes.
Okay, so to the extent that Ms. Goldie's $850 a week rate represents the ability to have her reliably participate for childcare for your children, you agree that that might be worth paying?
No, not really.
Why would it be, well, I guess you're not asking anyone to pay your nanny fees. You could pay her $10,000 a day, and right now, that's purely your expense. Okay.
How did you come up with the $1,500 a month that you're including in your financial affidavit?
I negotiated it with Rose.
Okay, but I guess what I'm trying to ask you is, do you contend that that full $1,500 a month that you've included in Petitioners 1 on page 4, you can look at it if it's easier, Plaintiff's Exhibit 1, it's on page 4.
Okay. Item 1, right?
Yes.
Okay.
And Your Honor, just for clarification, we use that as Respondent's Exhibit 6 to the extent the court ever, I do have a notebook for Your Honor, which may I approach and go ahead and give it to you, Judge?
Sure. You never have enough binders.
Oh, I know. I often wonder what you guys do with them after. Actually, you
It's
should-
funny you asked that. My judicial assistant is trying to figure out if there's a school that would take not the contents of the binder,
That
but the
would be
binder.
smart. That would be
Yeah, because
excellent.
we have a cabinet full of them. You open it and they fall out.
Right.
And they're very helpful here and now. Then this case is closed and we've got these binders.
We could come up with a collection with the family law bar, Judge. I'm sure we could just redistribute them at
Yes.
some point. Okay, so Mr. Deal, if you could look at Petitioners 1, do you see on page 4, I believe it's under Children's Expenses, you have Nanny Rose T at $1,500 a month.
Yes.
Okay, is it your contention before the court today that the $1,500 a month represents work-related childcare for you?
Yes.
Okay, and you think that's reasonable work-related childcare? Reasonable also, yes?
Yes.
Okay. And I believe you said that the way you calculated that was coming up with approximately $40 an hour for the hours that Nanny Rose works for you.
For those hours, yes.
Okay. And I think that you testified that there are times that Nanny Rose is delivering the children to school that you would be available to deliver them to school.
No, usually I would do it if I'm available,
When would you not be available?
if I was at work.
Okay. So your contention is every time that you're available to take them to school, you do.
Usually, yes,
What's the exception?
if I'm at work. Or if, I'm not able to, but usually, yes.
When would you not be able to when you're not at work?
If I was driving home from work. Or if, we're talking about the pickups from Anna's house, is that right?
No, I'm talking about times that Nanny Rose might be driving your children to a location while you are available also at the same time to drive them to that location.
The only times that Rose does anything with my children is when she picks them up from Anna's house, which she does on Sunday, Monday, and Friday. And so every once in a while on a Sunday, I'll let her pick the kids up, even if technically I could stop or what and go and pick them up. So sometimes, yes.
But you've included those Sunday pickups in the amount that you show in your financial affidavit, correct?
But
Yes or no?
I'm sorry, what, ask me the question again?
And just so we have this dynamic down, you do need to answer the question, yes or no, if there's a yes or no answer, but you always can explain it. So it may be yes, but it could be, I don't know, it could be maybe, or it depends, but make sure you answer the question and then explain to your heart's content. She'll ask it again.
Okay. So the Sundays that Nanny Rose is picking up the children, is that correct, from Ms. Deal's household?
Yes,
Those Sunday pickups are included in the $1,500 figure that you show on page 4.
yes,
Did my client work in the ER as a doctor during your marriage to her?
yes,
Did she have work-related obligations that she had to fulfill when she was not working at the ER?
yes,
What obligations were those?
no. Because because the thing I was thinking about was an ultrasound teaching course. It was voluntary, wasn't a work-related obligation.
What's charting?
That's finishing your paperwork from your shift.
When you and Ms. Deal were together and she was an ER surgeon, would she ever do the charting at home?
Yes, sir.
So that would be work, but at home rather than at the hospital.
Yes,
Do you consider catching up on sleep to be related to your professional competency at the ER?
I don't know about, it's too vague for me to know the answer to that. I don't know the
Well, let me ask
professional
it,
competency.
let me ask it a different way. I'm sorry, I don't mean to I'm not trying to talk over you. Do you think that it is important for ER physicians to be well rested?
Yes,
Okay, so would you agree with me that maintaining a healthy sleep schedule could be said to be related to your work as an ER physician?
yes, it could be.
Now, I believe that you've said that you want the court to take summer camp outside of the child support worksheet, meaning not put that cost into, not include that cost as a factor in your child support calculation, but that each of you just pay your own summer camp on your own time, right?
Yes,
And is it your contention that you and Ms. Deal both have approximately equal amounts of summer vacation time with the children?
yes,
Do you and Ms. Deal make equal amounts of income, Mr. Deal?
no,
So in making that request to the court, you're asking that each of you pay approximately 50% of summer camp costs, even though you do not make equal amounts of income. Is that correct?
yes.
Your Honor, if I may approach with yet another notebook for Dr. Deal.
Sure.
Thank you. Actually, before I move on to that notebook, Mr. Deal, has my client ever insisted that you pay any form of child support to her through Our Family Wizard?
No,
That was your election to do that, correct?
yes,
And when problems arose with payments being paid on time, did you stop using Our Family Wizard?
yes.
When?
We'd have to go look at it. I don't know.
Well, I guess what I'm trying to say is it sounded to me like you were trying to tell His Honor that the reason why my client would have had any problem getting paid child support on time was because of Our Family Wizard. Was that your contention?
Yes,
Okay. So if you were having problems with Our Family, how long did you have those problems with Our Family Wizard?
it's not consistent. It's unpredictable, but a year.
So you had problems for a year and did not change anything about the methodology of
not-
payment?
No, that's not what I said. I said-
Wait till she finishes her question before you answer,
Yes, sir.
but she finished.
Could you rephrase whatever you're asking me?
I said, so you waited a year during which you had problems with Our Family Wizard before you tried to change the methodology of payment?
No.
So what did you do?
When Anna told me that, so I had tried to pay Anna the payments to her through Our Family Wizard. She told me on a given month that it had not cleared yet. I tried to resubmit the payment. It also did not clear. The following, I'm sorry, let me change that. I tried to resubmit the payment, and that, on that instance I'm talking about, it did clear. A month or two goes by. I submit the payment through Our Family Wizard. Anna sends me a message in Our Family Wizard that says the payment has not cleared. After that had happened 2 or 3 times, I tried to switch to issuing her a check. Anna had suggested using Zelle, but Zelle has a number limit that's below what I pay her. So I'd have to break it into like 6 payments over, and you have to wait 24 hours. So that was not, I didn't think that was a good alternative. So I tried to send her checks. The first time I tried to send them through Bank of America, directly. When I issued the check, Bank of America told me it was like the 28th or 29th of the month that they had sent the check. Anna told me that, 5 or 6 days later that she did not receive it. I double checked with Bank of America. They said that it was sent. So I ended up having to cancel those checks and then resubmit her another check. So then I found another company to try to check that gave me a receipt of when it was sent. It still had a delay to Anna. She still complained about it. So then I tried to switch back to Our Family Wizard.
Have you ever tried to set up an ACH recurring payment from your bank account to her bank account?
Mm-hmm.
I don't think so. Maybe.
So
Would you be opposed if, I don't know how that works, but would you be opposed to using that channel if it is reliable, documentable, and they don't charge you $100 each time you do it?
Totally.
Okay, you're neutral on what the channel is as long as it's documentable. So if someone claims you didn't, you can say, no, look, it's right there. And it's reliable, so you're not having to deal with these headaches with the Our Family Wizard.
Yes, sir.
Okay.
Okay, and Mr. Deal, if you could please turn to page 4 of the child support addendum. In my notebook, the final consent order is behind Respondents Exhibit 1, so it's behind tab 1. And if you could turn to page 4 of the child support addendum. And Your Honor, I could move to admit this. It's part of the court's record, so I think that Your Honor could take judicial notice of it, but I could also move to admit it as the court wishes.
However you want to do it, is it in this docket?
No, so
I would admit it, because if it's in a different docket, someone might find it, but they might not.
move to admit, Your Honor, what's been marked as Respondents Exhibit 1.
Which is the consent final order that I called DeKalb, but you've explained it ultimately was here in Fulton because they were consolidated, and Judge Ellerby signed it in September of 24.
Correct, Your Honor.
Okay, no objection. Respondents 1 with all its attachments is admitted.
Thank you, Your Honor. So with that, Mr. Deal, have you had a chance to find page 4 of the child support addendum?
I think so. The
Okay.
signature page.
No, I'm looking at nanny costs. It's subparagraph E.
Sorry, I think I'm,
It's confusing. It's fine.
okay.
Take your
I
time.
found it.
All right. Do you see the subparagraph E, nanny costs? Do you see the sentence that says the father shall pay $1,828 per month to the mother, representing his contribution towards her nanny costs, currently $3,655 per month.
Yes,
So you agree with me that you knew how much was being paid to Ms. Goldie at the time that you entered into the 2024 consent order?
yes,
And you agree with me that you knew how much parenting time you would be receiving when you altered the parenting schedule as part of the 2024 consent order?
yeah, I think so, yes.
Okay. And
What about the consent order in 24 altered the parenting schedule?
Your Honor, it gave him Sunday and Monday overnights only. So he had his weekend, which would go from Friday to Sunday, but because my client was working overnights on Sunday, Mondays, and Tuesdays, the parenting plan was altered so that he would just get the children essentially from 6:30 p.m. until they were delivered by what was anticipated to be a nanny to school the following morning.
So it added the overnights.
Correct.
It didn't take anything away from Mr. Deal, but it added those Sunday, Monday overnights.
Correct, Your Honor. It also added to the holiday schedule somewhat.
Okay.
Yes.
But in terms of routine, the Friday, Saturday, every other, that didn't change. It just added every Sunday, Monday overnight to Mr. Deal.
Correct.
Okay.
Yes. And do you agree with me that, Mr. Deal, what you were supposed to have done is included the $1,828 per month in the payment made to my client I believe it was to be made on the first of each month.
Yes.
But you didn't do that, did you?
What, could you tell me, ask me the question again?
Did you pay my client on the first of each month, starting with September 1st, 2024, $6,228 every payment?
I attempted to, yes.
To your testimony, you did not send her one payment of $4,400 and another payment of $1,828?
Our Family Wizard doesn't let you submit a $7,400 payment all in one. So I broke it into the three, the child support, the daycare, and then the nanny costs. The numbers are listed in the worksheet, so I just paid each in three payments, all on the same day, and usually that works.
Where are you allowed to do that in Respondents Exhibit 1? Where does it say that's okay in this consent order that you entered into in 2024?
I don't know.
Where does it say it's not okay if it's paid on the same day? I mean, couldn't he have broken it down into $1,006 payments if they all go across in the same day?
I don't know yet. It says it's supposed to go together with the 4,400, although I understand what the court's point is.
Well, I'm not being nitpicky. It would seem like the focus would be, does father pay the entire amount on the day, whether it's broken into pieces technically because OFW, as we call it in the trade, can't manage something that big, just like Zelle. I'm not feeling like that's a violation of the order. It would be if he was holding off on the 1828. So I'm not going to pay that till the 15th. I'm annoyed by this one. I'm going to drag that one out every time. And that may be what you're about to show. But if it was, I couldn't send it all at once because of the $5,000 cap. I thought this doesn't seem illogical to me. Here are the three things I'm supposed to pay in the worksheet. And each of them is less than $5. So I'll send that one. And then 30 seconds later, I'll send that one. And then the third one. And I don't know what you can document and what you can't, but if the documents show that it's what I just described, that seems to me to be consistent with the intent of the September 24 agreement.
Understood, Your Honor. Did you do that, Mr. Deal? Divide it up into three payments that were all made on the same day on the first?
Yeah, yes.
You were represented by an attorney at the time that you entered into the consent order that we've marked as Respondents Exhibit 1, correct?
I don't know.
Did you have an attorney represent you in 2024?
Yes.
And did that attorney sit with you at any mediation or discussion, or did that attorney give you input prior to you entering into the 2024 consent order? I don't want you to get into what they said to you.
Yes.
So you were provided advice when you entered into Respondents Exhibit 1.
Yes.
And if you could look at paragraph 6A of Respondents Exhibit 1. Do you agree with me that it was my client's responsibilities on her responsibility on Sundays and Mondays that you kept the children overnight? It was my client's responsibility to feed and bathe them before they were delivered to you.
It does say that in this, the last line there.
Okay. So what happened with you when you had your parenting time increased to include the Sunday and Monday overnights? What you did is you provided beds for the children to sleep in and breakfast for them the next day and a ride to school. Is that correct?
Definitely, yeah.
And
But that's not all, of course, but yeah.
And weren't you supposed to use Ms. Goldie, the nanny who testified today, to get the children to school on your mornings with them?
I was supposed to try to use Melanie.
Okay, what I'm looking at is paragraph 6B, the second sentence. Do you see the sentence that says parties will seek assistance from mother's current nanny before retaining another provider if he needs assistance?
Yes.
So you agree that your talk about right of first refusal, you had to ask first if she could help you on your mornings before you were supposed to solicit another care provider.
That's right. In the afternoons. And I did ask her.
And at some point, well, during some period of time, she did in fact do that for you, did she not?
She told me she was unavailable.
There wasn't a period of time shortly after this order was entered that she did the morning drop-offs for you?
She does the morning drop-offs.
Wait, I thought you said she was unavailable.
She's in the afternoons. I just was confused by the question. I'm sorry.
Okay. But the morning drop off, so they arrive at your house, bathed and fed, you do what you do with them, they eventually go to sleep, you get them ready in the morning, and then Ms. Goldie shows up and gets them to wherever they need to be.
Yes, sir.
So under the 2024 consent order, you benefited from Ms. Goldie in that respect, correct?
In that sense, yeah. I mean, I paid for the benefit, but yes.
Right. And you understood what the amount you were paying was based on because we've already gone over the portion of the consent order that referenced her monthly rate, right?
I understood her monthly rate, if you're asking me that.
And it was an issue, was it not? Didn't you also contend in 2024, Mr. Deal, that Ms. Goldie was working for my client during times that she was not at work?
Yes,
So that was also an issue in 2024.
yes.
Okay, if you could turn from to what I've marked as Respondents Exhibit 5.
Tab 5.
Yes, please.
I got it. I'm tracking now.
Is this a true and correct copy of a letter that your attorney received from Ms. Deal's then attorney on April 18th of 2024?
I don't know.
Well, feel free to look through it, please.
I see that it's an email or a letter.
And do you agree that this letter contained the October 2023 contract with Ms. Goldie that your attorney has already entered into evidence?
Randy didn't give me every piece of correspondence that he had with Michelle, and I've never seen this, this particular email, so I can't really, I'm not saying that that it's not accurate, or that it is accurate.
If you haven't seen it, then you aren't the right person to talk about it.
Correct. But you concede, Mr. Deal, that this was similarly an issue in 2024. You thought that Ms. Goldie was working for my client when my client was not herself then working, right?
I did think that in 2024.
But you nevertheless agreed to include in the 2024 consent order the amount paid to Ms. Goldie that we've already gone over in petitioners, excuse me, what I've marked as Respondents Exhibit 1.
Yes, but if in our agreement, I asked Randy to add a sentence that said, if there was additional childcare outside of work-related childcare that I wasn't responsible for it.
Right, but the portion you were responsible for was the ongoing regular rate of $8.50 a week.
At that time, yes.
And her rate hasn't changed, has it, since 2023?
I don't know her rate, but her rate, she heard her say it herself that it's variable how many, she gets a salary and it's variable how many hours she works, meaning an unknown rate.
But whatever the figure is, if we call it a salary or a rate, she just testified it's $8.50 now. Sounds like it was $8.50 back when you were working through this.
Yes, sir.
And if you could also look a little bit further in paragraph 6 of Respondents Exhibit 1, I'm on subparagraph C of paragraph 6. Do you agree that there is a sentence that you included in this consent order that says parties agree to maintain mother's current nanny or equivalent replacement regardless of whether she provides AM assistance to father?
It does say that.
Okay, so do you agree with me, Mr. Deal, that that represents your agreement, at least at this time, that those nanny costs, the ones we've already gone over, were appropriate?
No, I don't know. I don't know what if you're asking me, this, like that sentence, you just asked me about that sentence. Michelle and his lawyer put that sentence there. So Melanie would not be forced to provide assistance to me if she didn't want to, because we did not have her present. That was we were sitting at a table all together. Melanie wasn't present. So she added that for that reason. I don't know, could you ask me the question again?
Do you agree with me that paragraph 6C represents your concession that the work-related childcare costs that my client had in 2024, that are the same costs she has in 2026, were appropriate to be included in the court's calculation of child support?
Do I agree that I'm just trying to figure out what I'm agreeing to here.
And don't agree if you're not sure what it
That's
is.
fine.
So do I agree that the costs calculated represented in this worksheet at this time were appropriate?
Yes.
Yes, yes.
And the children benefit from their relationship with Ms. Goldie, do they not?
Yes, I love Melanie. I think she's wonderful. So I love that, that she's in their life.
And you think that it's a long-standing beneficial relationship that exists between Ms. Goldie and your 3 children?
Yes, I do. But I also don't think that even the most wonderful childcare provider is a stand-in for a parent. So I don't, I would never put her in front of her mom or me.
Well, have you filed a modification of parenting time, Mr. Deal?
Yes, I have.
But is there a modification request of your parenting time before the court right now?
No,
Wouldn't that be a way of substituting your own parent care for childcare in this case?
Objection, asks him to make a legal conclusion. There's no basis for a modification of parenting time in the law. So asking him a question about his agreement to that is.
Okay, I hear your objection. I didn't hear the question that way. So why don't you phrase it slightly differently? I think I understand what you're getting at, which is what I'm hearing is, if you're frustrated that Ms. Goldie is basically playing parent in non-work time, well, but if it's work time for Mr. Deal, asking for more parenting time doesn't scratch that itch.
Okay. Why don't you tell the court what your schedule typically is, Mr. Deal?
Monday through Friday, 8 to 4:30, with a obligation to cover the 1/5 of the overnight calls of the year, which tends to be every 5th week in a chunk.
And can you identify any time periods that you have asked Ms. Deal to be able to take care of your children instead of Ms. Goldie?
That I asked Anna to take care of the kids instead of
Ms.
Melanie.
Goldie, yes.
No, I have no idea when Anna or Melanie or whoever is taking care of the kids, and I don't ask about that. I only know what she has said.
I'm just asking you to ask. Have you ever said to my client, I would rather that our children be cared for by a parent versus a child care provider?
I have said that in the past, yeah.
Okay, and have you asked her for the schedule so that you can see if you have any potential times that you could provide care
Yes.
for the children? Have you brought documents to show the court that today?
No, I don't know. Monica, did we bring those documents? Okay. Our family wizard, messages, probably have 30 of times of me asking for time that, that I could take the children.
Do you have any work-related obligations, Mr. Deal, that extend into hours that you're not actually at work?
I would say yes, because my job never ends. If somebody might call me and ask me a medical question at 10 o'clock at night. So yeah.
And isn't it possible that those types of obligations also happen during Ms. Deal's parenting time?
Yes. That's the thing about being a parent, is you have to balance that. I know exactly how it is.
And sometimes you need a little help from a childcare provider during those times.
If it's work-related time, yeah. No, but I don't know that I would try to hire a nanny to come to my house for, 4 minutes so I take a phone call. But I mean, Sure.
Does your fiance pay any portion of the $1,500 a month that you pay to Nanny Rose?
No,
Is Nanny Rose paid any additional amounts beyond the $1,500 a month?
every once in a while Spencer will use her on a night or something, or an afternoon. And she pays her separately for that.
Does Spencer have her own kids?
She has 2 kids.
And so the Ms. Rose would be taking care of Ms. Hewitt's kids.
On those nights.
Yeah.
Yes, sir.
So that's a completely separate, it's a happy coincidence because she trusts Rose because you work with Rose, but it's entirely unrelated to care of the 3 kids you share with Ms. Deal.
That's right.
Did you and my client have a nanny during your marriage?
Yes.
And can you tell the court when the nanny would work for you during the marriage?
The nanny would generally work during Anna's shifts. Yeah, generally during Anna's shifts,
And when were her shifts, daytime or nighttime?
both.
And so during overnight shifts, when you were available,
No, then the nanny would not work then. If I was at home and Anna was working, then the nanny did not work.
so when, if ever, would the nanny work an overnight shift?
If both of us were working overnight that night.
And did that happen upon occasion?
Not often, but every once in a while.
So is it fair to say that employing a nanny has been part of your family's childcare culture, for lack of a better phrase?
Yes. I was in my training at that time too. Training hours are, much more significant than out in private practice, unfortunately, but so it was harder then.
What prevented you, I want to turn to what I've marked as Respondents Exhibit 3. Could you turn to that, Mr. Deal? Do you agree with me that this is a true and correct copy of an affidavit that you put together in support of your response to our motion to dismiss?
Yes.
Move to admit Respondents 3, Your Honor.
No objection.
Okay.
It's admitted. This isn't any different other than it has the affidavit piece on top from the chart, I think that Ms. Hanrahan Freitag was using.
Hers is a bit more extended, Your Honor, but it has
Okay,
the
same numbers.
Same numbers,
Okay.
correct.
Got it. So Respondents 3 is admitted.
Thank you. And do you have to deal with numbers and math as part of your job as a doctor?
Yes.
I mean, that's partly why I'm not a medical doctor myself. So do you consider yourself to be fairly precise
I try to be,
and detail oriented?
try to be.
So what would have precluded you from calculating the new number of nights that you had in 2024 the same way that you did here in Respondents Exhibit 3 in 2026?
You're saying what? I don't know. I don't know.
You agree with me that you could have done this in 2024, had you cared about the number of additional nights that you were adding to your schedule, you could have undertaken the kind of math that you did in 2026, shown in Respondents number 3.
I'm not claiming that, or if you're saying I could have done the math beforehand, then I guess maybe, but to me,
I'm asking you, Mr.
Objection, allow him to complete his answer.
He was just about to say something more.
to me, we were all sitting at a table with our 2 lawyers, and we said that I will get 2 more nights a week while she's working, and then here's the worksheet. And so I said, okay, and so that was my interface with that decision. It wasn't a microscopic, dosing calculation, but so I don't know the answer beyond that.
I just want to understand how any part of the parenting plan you entered into in 2024 was unanticipated.
I had more days than the plan said that I was supposed to have.
So, but we talked about this already. You had the exact number of days that the plan described. Days and nights, the exact number. Every other Friday, Saturday, and every Sunday night, Monday night. That's what it, and you've done that, and no one is saying, hey, he's not been available. It just so happens that someone said that's 117, and that was a mistake.
Yes, sir.
And so you heard someone say scrivener's error, which is lawyer for a typo. And maybe it should have been 171 instead of 117, but it says 117. But do you agree, because this is what I'm wrestling with, that you actually have not had more responsibility for the children you share with Ms. Deal than everyone agreed to and negotiated and signed off on in the September 24 situation? They just hung the wrong number on that. Is that, am I understanding it correctly?
Yes, sir. That's correct.
So it would be correct both to say you haven't had any extra days and to say I've had a whole lot more than 117. Both those things are true.
Yes, sir.
And if 117 was a number that was used to drive some calculations, there might be a mistake in the calculations, but it's not that, gosh, I worked all these extra days. Ms. Deal's just been pushing the kids off on me in a way inconsistent with the agreement.
No, she hasn't done that.
Okay.
Okay, so towards that end about math, I think that the difference between 117 and 173 is 56 nights. Does that sound right?
It is.
Okay.
Okay, so if since 2024 you had 56 more nights with the kids, and I'm saying nights because we've gone through this, Mr. Deal, it's overnight, you get them after dinner and bath, you have overnight, and then you do breakfast and school delivery,
Well, they're
right?
not always having dinner and bath, and it's not always, but
But let's not get hung up on it. I appreciate that sometimes they may eat with you, et cetera. There's just a distinction between the full days of Friday, Saturday, and what I'm gonna call the evening, the sleepovers, the overnights.
well, I think if you're asking my opinion about that, then, like, for example, today, Monday, I brought the kids to school this morning. Melanie, it sounded like, but I don't know who, so, yeah, either Melanie or Anna will pick the kids up this afternoon. And then at 6, they'll come to, I'm sorry, it's Tuesday to now, but if it was Monday, then at 6, they would come to my house again. And then they stay overnight, and then the next morning, get them up, and then I would get them to school. So the overnights thing, it's like to me, it doesn't, register that way. But if you're asking me, is that the question? You're asking me that I feel like they're only overnights? Absolutely not.
Oh, no, you're saying that from an emotional perspective. To you, it's not quote unquote just an overnight, right?
Say that one more time.
To you, it's more significant emotionally than just an overnight.
Well, and time and logistics. So,
Okay,
yeah.
but if since 2024 you had, in one calendar year, 56 more nights with the kids, in what way would that change your mortgage?
It wouldn't.
And if since 2024 you had 56 more nights with the kids per year, in what way would that have changed your utility bills?
It might have gone up a little bit, a bit.
Have you?
They leave the door open in the winter.
I know my kids do that too.
Mhm.
Is it fair to say that you have not brought any calculation to Judge McBurney showing how much more of a financial burden those additional 56 nights per year were to you?
No, I'm not trying to itemize out the 56 nights. I'm just asking to recalculate the child support worksheet.
Would it? Remind me again how much you make per year?
Last year is 1.3 million.
And I think you already agreed with your attorney that you make more now in 2026 than you did in 2024.
Slightly, yeah.
And at the time of the 2024 consent order, when it was negotiated and agreed upon, you knew that my client employed Ms. Melanie Goldie, correct?
Yes,
And you knew that Ms. Goldie was being paid at a monthly rate reflected in the 2024 consent order.
yes,
And you knew that my client worked a certain schedule, Sunday, Monday, Tuesday overnights, correct?
yes.
And that schedule hasn't changed, has it, to your
Well,
knowledge?
I don't know if it changed, but so I don't know.
Okay. But you have no reason to believe that schedule has changed since 2024 as you sit here in court today.
No, I don't.
So if I'm Deal. What you're asking the judge to do is to reduce your $4,400 a month direct child support amount. That's exclusive of the nanny contribution. You want him to reduce that to $2,113 per month, correct?
Yes, ma'am.
And then you also want His Honor to keep extracurriculars, what we call outside of the worksheet, meaning that the court keeps in place the original child support arrangement where each of you pay 50% of extracurricular costs, and yours is capped at $2,500 per child per, it's either academic or calendar year, but I don't have it in front of me.
Yes,
Okay. And you want the difference to be with the summer camp. Before, in the original 2024 consent order, summer camps were divided 50-50, correct?
yes, I think so.
And what you're asking now is for that cost to essentially be left out of the child support calculation and each of you pay for childcare on your own time, even though you and my client do not make equal amounts of money, right?
Yes, the reason for that is because last summer, not only did Anna ask me to pay for Lily's daycare throughout the summer, but also in addition, summer camps, and it was really expensive. And so and it was also a lot of times that neither one of us was working. So I thought that since we have to have this discussion, then I would ask that we just pay our own summer camp to take that out of it.
Well, the summer camp and extracurricular costs on your financial affidavit seem fairly considerable to me, Mr. Deal. Do you agree with that?
I don't know how it seems to you.
Okay, if you would, that's fair. If you would turn to Respondent's Exhibit 6, which was already admitted as Petitioner's 1.
Okay, I'm on Exhibit 6.
Yes, thank you. And if you could turn to page 405.
Okay. I'm here, I'm there.
Okay, and you have summer camps at $1,600 per month. Do you see that?
Let me find it.
It's a-
Lower right-hand corner.
Correct.
Yes, yes.
Okay, well, that's not a small number, is it? I mean, that's 1,600 times 12, right?
No, it's like, for example, slime camp for 3 kids, and it's like $400 a kid. You can get to 1,600 quickly if you're choosing to do that. So.
Well, this is me just channeling my English majorness, Mr. Deal, but I mean, I'm coming up with 1,600 times 12 as being $19,200 a year. Is that how much is typically incurred by you for summer
Oh.
camps?
No, I don't think so. I don't know. Or maybe when I filled this out, maybe I had listed the prior year's summer camp that I'd paid for Lily and for all of their stuff and a Kate or something like that. But you're right. $1,600 times 12 is too much. I haven't paid that much in summer camp.
In your family culture, do children attend overnight summer camps ever?
No.
I don't know, I'm just looking through. I think I'm about finished.
I might have meant to write 160 there, but I don't have all the math in front of me now.
Is it possible that you took that figure from one of my client's child support worksheets and you just assumed it was accurate?
No, I don't have her worksheets.
Mr. Deal, wasn't an automatic child support reduction included in the 2024 consent order? Do you know what I'm talking about when I say that?
No.
Okay. Wasn't it true that once Lily, your youngest, is no longer she no longer has daycare costs, does she?
No, right. That's
Right. And wasn't there a portion of the 2024 consent order that automatically reduced your child support amount when she no longer had those costs?
Yes.
And you have benefited from that self-effectuating reduction, have you not?
Yes.
You're paying less now than you did at the start of the 2024 consent order, correct?
Yes.
Okay. And I'm looking at page 2 of the child support addendum, which again is Respondents Exhibit 1.
Okay, I'm there.
And do you agree with me that your original monthly total that you were paying, I'm at paragraph 4, the child support amount. Do you agree that the original monthly total that you were paying between the nanny contribution and the daycare costs and the direct child support amount was $7,878 per month?
Yes.
And that when Lily no longer had those daycare costs, you got an automatic reduction to $6,228 per month?
So, yeah,
And that actually has already gone into effect, hasn't it?
yes,
And it went into effect while this modification action was ongoing.
yes, yes,
And despite knowing that that automatic reduction was coming, you elected to file this case in January of 2026.
yes.
When you say it's coming, when, I must have missed one piece. When did the reduction kick in? Just this fall? Well, I say fall, it's still summertime, but basically in early August, Lily began kindergarten. And so going forward, if nothing changes as a result of this, you'll be at 6228 rather than 7878. So a reduction of $1,600 a month, which is however much you said summer camp would be if it was $1,600 a month for 12 months. Okay, got it. All right,
Thank you.
you bet. I'm gonna let you do redirect. I need to make sure our court reporter doesn't need a break. We will, you're good? She's good? Okay. What I think we'll do is finish with Mr. Deal's testimony and then give everyone a quick break. Lunch break is going to be closer to 1 because of my 1 o'clock, but I want to give people a break. We've been at it now for over 2 hours. Unless your redirect is 45 minutes.
I don't anticipate that.
Well, let's see how long it goes.
Mr. Deal, have you asked Ms. Deal for overnights on Tuesday?
Yes,
Did you ask Ms. Deal for overnights on Tuesday in 2024?
yes,
The 2024 agreement, what was Ms. Deal's response?
no, that they were going to stay with her.
Tuesdays are nights when she is doing her ER work.
Yes, sir.
You asked, you may have answered this, you asked for that in 2024.
Yes. I've consistently asked for any time that if she was going to be out of town or working overnight, could they come to stay with me? And yes, in 2024, probably before that.
The 2024 agreement you reached was a comprehensive agreement for parenting time and child support.
Yes,
At the time, prior to the 2024 order, you were seeing the kids about 4 days a month.
that's right.
Pursuant to the 2024 order, you were seeing them closer to 40% of the month.
Right.
Were you willing to make concessions financially to secure that parenting
That's
time?
exactly what I did. Yes.
What were the financial concessions you made?
Well, the child support went up. Which was, it was recalculated. It was recalculated.
Okay,
And,
but the figure was higher as a result of the 24 settlement than it was before,
yes, sir.
even though you were getting more time with the kids.
Right.
Okay,
Because when we had divorced, I was an associate and I was buying into the practice. So I made significantly less money.
got it.
And then a year later, I finally made it to a partner.
Okay.
So, yeah.
Did you believe the cost of Melanie was reasonable in 2024?
Did I believe it? I believed it enough to be willing to agree to it. I had questions and I asked Anna then about would the nanny, would that much childcare be needed? But it was worth it at the time to make that agreement work. So the question is, will you ask me it one more time? I'm sorry.
Did you agree that the cost for Melanie was reasonable?
Yes, yes,
Was it part of a comprehensive agreement?
yes,
In isolation, did you believe that amount was reasonable?
No,
Did you believe it was reasonable to pay for daycare and a nanny?
no, and there was significant overlap. Like the year prior to that, and which is what created that agreement or whatever. The year prior to that, Anna had sent me a specific day, like the nanny worked this day, this pay me this amount. But all those days would come across and they'd be days where the kids were actually with me, or there'd be days where the kids were in daycare the majority of the day because the daycare sent a attendance thing to me every day. So when they're checked in and when they're checked out. So I said, well, this isn't right. So anyway, no.
Um, Have you reimbursed Ms. Camp for all summer camps for the kids?
Who's Miss Camp?
Anna.
By mistake, Ms. Deal.
Is that the same person?
No, Ms. Camp is, I was talking about camp and I.
Oh, got it. You got the word switched.
Sorry.
I just wasn't sure. I heard Miss Deal had remarried and so we have another name now. Okay.
Ms. Deal, have you reimbursed Ms. Deal for all summer camps?
I think so, yes. Yeah, anything that she has sent me in our family wizard, I've paid it. And so there's been summer camps. I don't think this year they didn't do as many summer camps. To my knowledge, they didn't do any at my house, but
Have you rejected any expenses Ms. Deal has placed in our family wizard?
no,
Not for healthcare reimbursements?
no.
Not for summer camp?
No.
How about extracurricular?
The short answer is no, but we had agreed that the children were going to stop swimming and go on to a different extracurricular, and then Anna continued swimming. And initially I tried to say, well, then, we agreed not to, then you pay for the swimming, but then I went ahead and paid it anyway. And I've paid it since then, and I think it was a mistake to even say that. But so the short answer is I haven't rejected any payment.
I think I heard you testify you took the kids to school this morning.
Yes.
Why not Ms. Golden?
I didn't know if she was coming because sometimes she sleeps in, sometimes she doesn't come. It got to be 7 o'clock. I knew if it got any later, so I went ahead and took them. But I had intended that she would take them because we had court, but in case super traffic or something, but she was late, didn't contact me. And so I took them.
Is that a frequent occurrence that you're left wondering, are you going to show up or not?
Yes, yeah, at least once a month, but yeah. And that it's hard because, Melanie works for Anna. And so I can try to, kind of ping. They're like, hey, are you coming to, and generally the night before I send a text and say, just confirming you're going to be here tomorrow. And I sent that Sunday, she confirmed she was there Monday, but I forgot to send that text Tuesday night or Monday night. And then it occurred to me that she was probably going to be in court. So I was like, I just went ahead and took him.
You shared that on Sunday, Nanny Rose picked up from Nanny Melanie.
This most recent Sunday, I picked the kids up from Melanie. Yeah.
Did you pay Nanny Rose for that day?
I don't remember. Probably yes. I think so. I think I paid her anyway.
On this past Sunday, just 2 days ago, you anticipated picking the kids up from Ms. Deal?
This past Sunday. Okay, 2 days ago, the nanny, Rose picked the kids up from Anna.
Okay.
The week before that, I picked up. Sorry about that.
The week before that, you picked up from Melanie.
From Melanie, right?
Do you have any concerns about using ACH for the non-standard reimbursements?
Yes,
What is that?
it is very hard to track and prove that you consistently paid it. And Anna has said that in the past that I have not paid things that I then had to prove that I had paid. And I don't want to run into that again. Our family wizard tracks it and the payment goes item by item.
Do you know a way to do that within ACH?
And ACH is just a bank transfer. Is that right?
To my knowledge,
Yeah,
yes.
you don't get to ask her questions, but we will work through. One thing that will come out of this will be a refinement to the way in which money moves back and forth. And it may be that there are two channels. If there's something that is the same every single month, why not ACH that one? And then you don't run into especially if it's more than 5,000. But you're being, I find, very reasonable in saying, I want it to be documentable, so we don't butt heads of you did pay or you didn't. But I think it's very reasonable for Ms. Deal to expect things to arrive pretty much when you send them. And if they're not arriving then, because it's your fault, but they just aren't, we need to come up with a different channel. So we'll work through that.
Do you believe Nanny Melanie is overcompensated?
Yes.
Why?
Well, it's complicated. Melanie lived with Anna for I think 6 months. So, I don't know. I don't have any insight into their relationship, and it's fine as best I can tell. Is Melanie is great with the kids, but in terms of being legally required to pay that kind of money to her, you would think that she had significant work-related work hours, which she doesn't. So based on that, I think that she's probably overcompensated.
All right. Her work-related childcare hours are the Tuesday overnight.
Right.
And what else?
I don't know what else. Nothing.
Is it your position she could deliver the children? They're with you Sunday and Monday. So Tuesday overnight. Does she need care on Wednesday?
Well, I don't know. I think. Oh, and I said Melanie also brings my kids to school on most Monday and Tuesday morning, so that's also work related. So I left that out. Wednesday, I guess to bring them to school Wednesday morning.
Could Anna Kate do that when she gets off her shift at 7 a.m.?
She could. That's like when I finish a shift and I do something with the kids, but she could.
Okay. Does she need work-related childcare on Thursdays?
No, unless she works.
Does she need work-related childcare on Friday?
No.
Saturday?
No.
Sunday?
No.
Nothing further right now.
Super briefly, Your Honor, I promise.
Okay, famous last words.
I know, Judge, but I promise I'll try. Mr. Deal, I was trying to sort of recreate something I thought maybe the court was doing when we were speaking with Ms. Goldie. Do you agree that the 2 hours she spends delivering the children to school on Monday, Tuesday, Wednesday, and Thursday are work-related?
Yeah.
Okay, so that's about 8 hours right there?
6 hours or at max, probably more like 3 hours. But
I was thinking Monday, Tuesday, Wednesday, and Thursday.
no, not Thursday. Monday with me from my house, yes. Tuesday from my house, yes. Wednesday, if her mom works overnight, Tuesday night, yes, in the morning.
Okay, so you're coming up with 6 hours there. What do you consider to be an overnight shift in terms of hours for coverage by Ms. Goldie?
I didn't say 6 hours. I said 3 hours, but an overnight shift? Well, I don't know when Anna works. So when does Anna, or I can't answer her question.
You
Whenever
don't.
she works is when the shift would be,
Okay.
with maybe a little bit of time for
Well,
her to get.
Let me ask it this way. Do you think it's possible that there are 20 hours of work-related childcare to be provided by Ms. Goldie in any given week?
Probably not. It's probably, 9 or 10 hours when the night Anna works, and then 3 hours it's probably like 12 hours, maybe, probably very similar to what I use with the three. I use 9 hours.
Well, I guess what I was trying to figure out, you've already testified that you think $40 an hour is an appropriate and reasonable rate because that's what you pay Nanny Rose, correct?
No. I chose to pay Rose that for my own convenience and consistency. I didn't ask Anna to pay that, but so no, I don't think it's an appropriate rate for a consistent person that you're paying on salary, no.
Okay, so you think $40 an hour, you wouldn't pay that for flexibility and reliability. You think it's worth your time, your money to pay $40 an hour for reliability and flexibility, but my client shouldn't be able to pay her child care provider for that
Well, I don't
those
think
same
that.
two concepts.
Don't think that, but I had to pay more to get a childcare provider to work these little discrete periods and be 100% reliable. So I did have to pay more than what I would say is the average rate for that.
Okay,
I'd love to pay her less.
right. But you think that that higher hourly rate is partly a product of somebody agreeing to be flexible and reliable as a child care provider?
Yes, yeah.
Okay. And when you were talking about the negotiation in 2024, the amount of parenting time that you received, the increase was important to you, right?
Yes.
And it was so important that you were tying it somewhat in your testimony to the issue of child support. Knowing the amount of parenting time that you were getting, you agreed knowledgeably and consciously to the amount of child support in the 2024 consent order.
Yes.
And when you filed this case, you did not file this case on the basis of having exercised more overnights with the children than anticipated, did you?
I don't know.
All right, I want you to turn to what we've marked as Respondents Exhibit 4.
Okay.
Is that a true and correct copy of the complaint for modification of child support that you filed on January 16th of 2026?
Yes.
And could you turn to page 2, paragraph 7 of that complaint?
Yeah, I'm there. Read it or?
Well, let
I
me,
can read it.
yes. Where in this complaint do you reference anything about exercising more parenting time than anticipated in 2024?
Let me read through it. I see the substantial decrease in need for full-time nanny. Yes. Let me go back to,
Kyle, it's not there.
oh, okay.
Well, I mean, changed circumstances, arguably, that could be the changed circumstances, just not articulated as I have more overnights than originally contemplated.
That's fair, Your Honor, and then under the notice pleading concept. I don't
Right.
have anything further.
Okay. Mr. Deal, you're done with your testimony for now, probably for the trial, but I can't guarantee that. You can step down. You can leave all the binders up there. We're going to take, this is going to seem like a short break, but we'll stop a little before 1 for lunch. So let's try to keep it to 5 or 6 minutes. And when we get back, well, let me find out. Do you have other witnesses you're going to call, Ms. Hanrahan Freitag?
I'm just Misty.
Okay, great. So Ms. Deal, you're going to be up next. Ms. McCormick, are you planning on, when Ms. Deal is testifying, getting out everything through your cross, or you'll also recall her after she steps down?
Your Honor, my hope is to not play the bobblehead game and only have both of them on the stand one time.
Great. Okay, sounds like a plan. We'll reconvene in 5 or 6 minutes. Thank you.
Is this your verified domestic relations financial affidavit?
Yes.
Move to admit plaintiffs 2.
No objection, Your Honor.
Admitted?
Your salary, your gross monthly income is 31,000.
Yes.
How long have you retained Nanny Goldie?
3 years since 2023, October 2023. She worked as a babysitter for us before that occasionally.
The current plan, parenting plan in place has been in place since 2024.
Yes, yes. His and I's parenting plan.
Correct.
Yes, yes.
Correct.
What other parenting
No,
plans?
I took a moment to process.
Okay.
Sorry.
That's all good. I just want to make sure there wasn't another set of parenting
No,
plans
there
floating
is
around.
not.
Okay.
No, just an awkward me.
Okay.
In the 2024-2025 school year, Nanny Melanie did not work Wednesday and Thursday mornings.
Always Wednesday mornings because I work Tuesday night.
Okay, she did not work Thursday mornings.
No,
Thursday morning,
usually no.
Thursday morning was an addition in the last 3 weeks.
Yes.
And her compensation didn't change, though her hours did.
Yes, I mean, that's kind of the point of the 850 is that it provides a flexible framework that can grow with the needs of the family while still providing her a stable income.
What is your work-related need on Thursday mornings?
Right now, it's that I can't do the flop between nights to days. You know, it is very hard to work until 5 a.m. 3 nights of the week and then to wake up at 5 a.m. that next night. And I was creating an enormous sleep debt. So it's something we've been talking about for a while, but like she said, she had the obligation to the other family and felt the need to finish that. And I respect, you know, that type of work ethic. So it's something we'd been talking about for a while, but now we were able to start it.
What work obligation to the other family?
She was the care for where the glorified chauffeur, in Melanie's words, part would have kept her from being able to do some of the schedule that we were talking about.
How did the schedule change 3 weeks ago?
So 3 weeks ago, she does pickups from either Kyle or I's house, Monday, Tuesday, Wednesday, and Thursday. And then drops
Pick up
them
in
off
the
at
morning
school.
or
Pick up in the
evening?
morning.
Sorry to interrupt.
No, it's okay. I know it's easy to me because it's my daily life, but I understand it gets complicated to follow. So basically 6:30, somewhere around there, she picks the children up from either Kyle or my house and drops them off at their school.
Monday through Thursday
Yeah.
mornings.
Monday, Tuesday, Wednesday, Thursday.
Got it. Friday morning,
Friday morning, I do it.
you do it. And how do you pull that off if you can't pull it off Thursday?
I shifted a little bit. It's really hard to go to sleep on time on Wednesday after I've been up for 3 nights
Mhm.
in a row.
So you're able, by Friday, you can adjust a little bit.
Yes.
Okay.
So you described 4 shifts, Monday, Tuesday, Wednesday, Thursday mornings. What
Yes.
else?
And then she picks them up from school, which was a hard thing for me to let go of, but sometimes you kind of have to recognize your limitations as well. She picks them off and I take over care immediately, like when she puts them at my house, you know.
Okay, what time is pickup from school?
It's 2:30, about 2. I think the carpool line opens at 2:20. So 2:20, 2:30 is pickup from school.
And approximately what time are they delivered to you?
Between 2:45 and 3 o'clock, depending on the carpool line and traffic.
And Ms. Goldie does this Monday through Friday?
Monday through Thursday.
Monday through Thursday again. You do Friday after school, or that's where dad kicks in?
No, he never picks them up until on his Fridays. He picks them up every other Friday at 6 p.m.
From you, not from school.
Correct.
Got it. So
After school.
you are the Friday pickup from school person,
Yes.
not Ms. Goldie, not Mr. Deal.
Yes.
Okay.
And I mean, no one asked, but my plan is like on days when I'm caught up on sleep or caught up on charts, I'll be like, hey, I'm going to grab the kids from school. You know?
Okay. But Friday, regardless of whether you're caught up from sleep or charts, you get them from school.
Yep.
Okay.
On a Wednesday at 2:30, you've been off shift since 5 a.m.?
Mhm.
And you go on duty at 3 p.m. when the kids are returned to you. I'm asking, why do you use Ms. Goldie for a half an hour pickup?
Because it lets me sleep longer. Because like she said, you have to get in the carpool line at 1:30. You know, I get home at 5. I'm not in bed until 6, you know. I'm not 25 anymore. I cannot just roll on 6 hours of sleep. I have I've had to do that in the past. And it's not a sustainable thing to be able to then show up and take care of patients overnight in a, demanding job.
Tell me what you would describe as Ms. Goldie's window on the mornings, Monday through Thursday, 6:30-ish is when,
I would say from what I've heard on the day she picks up from there, it'd be like 6:30 to probably about 8.
and when she's picking up from you?
And this is assuming you don't count her travel time. If you count her travel time, I would add 30 minutes to either side
Okay,
of that, because she's at Hertz Ferry at 8. But
okay,
for me, it would be 6 to the same time, 8:30, depending on whether you want to count travel time.
okay. And then when Ms. Goldie is picking the kids up from school, she hits carpool line at 1:30.
Mhm.
And when is she getting them to your house?
About 3.
Okay. She testified, as you heard, that she doesn't, sometimes it'll be 3:00, good seeing you kids, gotta go. And other times it'll be, I'm gonna stick around, maybe I'm here for dinner. How would you describe what drives, whether she drives is sort of a confusing term since she's driving, but under what circumstances would she get out of the car with the kids and say, I'm going to stay at the Ms. Deal household instead of zooming off to go get the other kids?
It's not frequent. Like 2 weeks ago, Sarah and I had a meeting, and so I was coming back from here at 3, so she stayed till 4. Sometimes on some Tuesdays, it's convenient for her just not to go back through Atlanta traffic for 2 hours, and she hangs out. I don't really count that choice as on the clock time.
Okay.
She may, but she's not obligated to be there.
So it would be more typical if I were to knock at your front door at 3:45 on a weekday afternoon, Ms. Goldie is gone.
Yes.
On a typical weekday afternoon, she's gone, you're there, the 3 kids are there and anyone else in your household, but not Ms. Goldie.
Yes.
Okay. Got it. So are those the shifts then, Monday through Thursday morning, Monday
And then
through
Tuesday overnight.
Tuesday overnight? Right. Okay. And so that would mean that Tuesday at 1:30, she's in the carpool line to get the kids. She brings them home, and she stays there unless she has to dip out to get these other kids until the following morning, when she takes them to school. And so that would get her all the way to 8 a.m.
Yeah, when I calculated it out, when I was just kind of trying to check that it was a fair wage, we don't count hourly at the same time, you don't want to shaft anybody or overpay. It winds up being about 30 hours over the course of the year, counting in like vacation and stuff, which is stipulated in our contract, and it comes to about $27 an hour, which is a pretty standard rate on the market. We didn't use a nanny agency, but I've used nanny agencies in the past.
Yeah.
And the nanny before her, that was her rate for a similar schedule.
Okay. So there's a big chunk of hours every Tuesday night.
And then the summer is totally different, just to make things super complicated.
I understand. And we've gone around the summers but I'm just wanting to work through.
A typical base school year week is like that, assuming
Okay.
that there's school on Monday because holidays fall on Monday.
Sure. And there's a holiday on a Thursday.
Yep.
But in summers, if they're going to summer camp, there could be some structural similarity because she needs to get them to summer camp, and she needs to pick them up from summer camp.
I've been waiting to speak to summer camp.
Okay, well, I'm gonna let the lawyers ask that. I just wanted to understand.
A lot of summer camp.
Okay, well, clearly the lawyers are wanting to talk about that. So they'll cover that with you.
You are married.
Yes.
Your spouse resides in your home.
Yes.
Why do you need overnight childcare on Tuesday?
He is a small business owner and works an unconventional schedule. He has a restaurant, so sometimes frequently he is not available during those hours.
How often is he not available?
I mean, enough, I would say at least 50% of the time.
When you say unavailable, he might not get home till midnight on a Tuesday night, or he gets home at 8:15 on a Tuesday night, or you may not know, you're working.
I mean, it depends on the where and the why and the staffing and everything. And it's about to ramp up more because they're gonna provide the food for a number of like these revamped Bury the Hatchet places, which are open later. So I would say like, like frequently not until like 8 or 9, and it's, Mel does not also want to go all the way home and come all the way back at
Okay.
6 a.m. His other job, he's a busy man, is a contractor, so that job starts really early. He works, he hustles.
Kyle has asked you for Tuesday overnights.
Not,
I'm going to interject here just for a second because I'm intrigued by the Tuesday overnight, but I don't think it's on my plate. Is that correct? You'd agree it may someday, since this is a FAM Div 2 case, and I'll let you explore it, but I just want to make sure I don't get too intrigued by that and say, hey, one thing we're going to do is Tuesday overnights.
Sadly, no.
It's not part of as Ms. McCormick went over your client's petition, I didn't see that in there. And even though we may be prying the door open on, we're really prying the door open on the child support piece, not the parenting plan.
Cool.
Okay.
yes and no. He has asked for them before. He also has said directly to me right after this 2024 thing, he goes, I would never take the Tuesday overnights from you, because then I could take full custody from you.
Have you considered a lower cost nanny?
That's really hard to find for someone that is going to, reliably show up. Honestly, I pay less for my nanny than my coworkers at work do.
Do your coworkers' nannies work the same number of hours?
Similar.
Similar.
Yes.
I mean, because they may pay more, but it may be that the nanny works 7 hours a day. And then, of course, they're going to pay more.
No, I mean, it's similar.
Okay. These would be coworkers with your same atypical schedule.
Yes.
Mr. Deal is current on child support as we sit here today.
Yes.
Mr. Deal has reimbursed for every healthcare expense. Mr. Deal is reimbursed for every extracurricular expense.
Yes.
What are the children enrolled in?
Okay. So we have ballet for the 2 girls, flag football for Jamie, the middle. We have cooking for Sylvia. And we're finishing up soccer. There was just a little bit of overlap, but we're not doing soccer and flag football. Oh, and we have piano. I knew I was forgetting one. Piano
Yeah.
for the older 2. It will eventually be all 3. The youngest one's just a little too small.
Approximately how much does that cost?
Piano is about $400 a month. I think ballet is $160 a month. And flag football, I'd have to break that down because I just paid that in a big chunk. It was like $300 for, I think, 3 months of it.
Excuse me.
So I guess that'd be $100 a month, but something like that.
How about cooking
Cooking, 160 or 180.
or lesson?
No, per month.
You rely on a nanny and summer camp.
No, so we didn't use summer camp last year. I used a single day for Melanie's deposition, and that was, and no, I used one day when Melanie was on vacation on Wednesday, after a shift.
Meaning
That's it.
you use one day every week or
No,
in the
the same
entire
day.
summer?
2 days in the entire summer of summer camp.
This was last year. I mean, well,
Yes.
this summer of 26.
Yes. And the year before that, I used 2 weeks of fun summer camp for Jamie and Sylvia each, because apparently it's not cool to hang out with your mom every day during the summer. But
It's
they
not.
got to pick what they wanted to do. It was treated more like an extracurricular, and they were not on the same week. So like Sylvia would be home all day and Jamie did Ninja Warrior camp. You know, it wasn't like that. And you have to pay for a whole year of of preschool and pre-K. You can't just like electively say, I'm not going to pay this summer without having to reapply. You know, the next year they give that spot away. Otherwise, they wouldn't be able to stay open. So Lily would sometimes go to pre-K preschool, but that's not summer camp. That was just preschool.
Why was it important to keep her enrolled in preschool going into kindergarten?
She didn't this last summer. She wasn't. That was 2 summers ago. I was still speaking to 2 summers ago. She wasn't in preschool this summer. She was home.
She was home, but Mr. Deal's child support obligation didn't reduce until August.
It reduced in May. According to the contract, it should not have, but it seemed silly to make him pay a fee that we weren't paying. That, I mean, the spirit of that is that while she was in pre-K, he would pay it. So we just both said like, hey, we're not, after May, we're not paying. Don't pay me this amount of money, you know?
What were Nanny Melanie's hours in the summer?
So in the summer, she would come in the morning around the time that Ozzy had to go. Well, okay. She would either pick them up from Kyle's house and bring them back to my house during the day, or come in at the time that Ozzy was, getting ready to go to work. And what's
Ozzy would be
I'm sorry, Ozzy,
restaurant
my
guy?
husband. Yeah.
Okay.
And then she would stay till about 1.
And then you would come back and be available for the kids.
You got to say yes or no.
I'm sorry, yes,
It's okay.
But you're not available at 1 o'clock during the school year.
they're in school.
You're not available at 1:30 or 1:20 for the pickup line.
Emphasis on, I've learned that I acquire a lot of sleep debt when I try to be awake and up and available at 1.
You didn't increase Nanny Melanie's hours 3 weeks ago in anticipation of this litigation.
No, I
correct?
did not. Like I said, this is something we had been talking about for a while.
Can you describe Nanny Melanie's other obligations to other families or work?
I know that she does I think it's 2 girls. She takes them to their extracurriculars or picks them up after school extracurriculars. And then I think she has another family that she helps on occasion. I wouldn't call it like, an every week thing. But it sounds like it's kind of a mother's helper or a, sometimes morning thing. And then she is a comedian and karaoke, that type of entertainment thing. She likes to do that as well.
What did the kids do this summer if they weren't in summer camp?
They hang out with friends. They went to the pool. Trampoline parks are like the best easy money spent, especially when it's really hot, to let them go be crazy. She comes up with really cool stuff. They went to Firm Bank. We had a Firm Bank thing. They did that.
Okay.
She comes up with really cool stuff.
She meaning the nanny.
Melanie, yeah, on those days that she's with them. But yeah, no, we hung out. They're getting to that age too where they have friends in the neighborhood and want to go to the friend's house
Yep.
and do the stuff with the friends.
Nanny Melanie was pretty clear that there were summer camps this past summer. She testified to it. What is the inconsistency?
I don't know. I don't know why she said they went to summer camps this summer. They didn't, so I'm not sure.
They didn't do swimming that she attended?
They went swimming. That's not summer camp. That's an extracurricular. It's swim team in the neighborhood, and she'd bring them to their practices in the morning. But that's like a hour and a half situation, not a full day. And you can't just drop them off and say, peace.
Mr. Deal hasn't asked you to reimburse for any summer camps during his time, correct?
No.
You vacation with the kids?
Yeah.
About how many weeks a year?
We try to do two like big ones, you know, and then like I'm taking my oldest to Austin with my sisters for a little, well, not on her birthday, but a little bit after her birthday. You know, we do smaller trips to Savannah. I'm from Savannah. That's why.
How much do you earn annually?
I think like about 350,000.
Do you take overtime shifts?
Not frequently, no.
Would, Nanny Melanie cover those times?
Yes.
Would you agree that Kyle also needs work-related childcare expenses?
If he says he does, I don't think it would be unreasonable. We did when we were married.
Why would you do overtime or not do overtime? I know why you wouldn't, but why would you occasionally do overtime? Is it required or?
Like right now, we have someone who's out for 6 weeks. And they offer, you know, they say, hey, we gotta cover the next 6 weeks. and
Okay,
we
so
all-
people are pitching in.
We all pitch in, and sometimes they do offer up shifts, say, hey, we could not cover this with the regular schedule and are willing to pay enough that I'm willing to work that night, but it's not like a super common thing. They can also just schedule me to work me an extra shift, but they have to pay me for it. Technically, that shows up in my overtime pay, but it wasn't elective overtime.
I couldn't hear that.
It wasn't sometimes they can schedule me non-elective overtime, but if it's more than 13 shifts in 1 month, they have to pay me for it.
Time and a half.
No, just regular. They just have to pay me for it. My salary works out to paying me for 13 shifts a month.
What time do you leave the house to begin a shift?
I leave about 7:15 p.m.
And what time do you arrive home?
Assuming that everything goes well for the night, 5:30 a.m.
Why don't you get the kids ready for school? It's like anyone else getting off a shift. There's dinner and bedtime. Why not do the morning drop off?
Because I've been up from 1 p.m. until 5:30 a.m. and I just completed a 9+ hour insane shift. I'm tired and there's no, you know, if I have a critical patient at 5, I don't get to just walk out that door.
Are you asking for extracurriculars to be handled within the child support worksheet or outside?
Outside.
You're aware that your 2024 order included both?
When you say included both, meaning included extracurriculars in the child support worksheet?
Yes, Your Honor.
Why do you, Ms. Deal, care where extracurriculars are accounted for?
Particularly don't. It has been historically his preference that he likes to do it outside of it. I don't really.
Okay, but you're willing to, if it matters to him and you're neutral, let's have it outside.
Interpreted the question of, is that what we put forth with this? And yes, but honestly, I don't care.
Okay, you don't have an objection. If there's a strong feeling on the other side, having the extracurricular payments and calculations and whatnot inside versus outside
None
the worksheet.
whatsoever.
Okay.
Has our family wizard been good for non-standard reimbursements?
What is non-standard reimbursement
A
mean?
one-time expense like healthcare
Yes.
or summer camp?
Yes.
Thank you. Sarah will have some questions, or I anticipate she will.
I bet. But we are kind of close to, when we're going to break. And so rather than have you do 5 minutes of questioning and then we stop, I guess we'll stop now. If you don't mind being back at 1:50, 1:50, I don't know how long this is. It's blocked out for an hour. The call have to be on, but it could be shorter. And so if you're in place and it's shorter, we can get rolling at 1:50. Does that work for you, Ms. Hanrahan Freitag? Okay, Ms. McCormick?
Yes, Your Honor, probably I can be more streamlined if I don't start right away. I'll try to be efficient.
All right, sounds good. So Lieutenant Volley, we'll be back up at 1:50. I'll be on a Zoom, but if it ends early, then we'll get rolling then, okay? Thanks, everyone.
Ms. Deal, could you describe how you and Mr. Deal used nannies when you were married?
So we always had a nanny ever since we had our first kid, and they covered, the times that we were working in the years right before our divorce. They mostly covered or followed my work schedule. I was part-time then, and they would work when I was working for the most part.
Have you ever been able to find a nanny that you could hire who met your needs, who did not require a minimum guaranteed rate of pay?
No, in fact, when I scaled down to part-time, we still had to pay our nanny the same amount, even though we weren't using the same amount of hours, just because in order to find someone who's going to provide regular care for the whole year, they have to live and make a salary.
Okay, and could you scoot a little bit further for him? And what you've just testified to, that you have only ever been able to find nannies that required a certain guaranteed minimum amount of pay. In your opinion, is that consistent with market for nannies?
Yes, absolutely.
And do you consider all of Ms. Goldie's work hours for you to be related to your own work?
Yes.
And why is that? Can you please explain that to His Honor?
I mean, because even when I'm not on my shift, in order to show up and do the high level work that I need to be, I need to be well rested. I need to be clear headed. And then in addition, I bring home a ton of work. I saw 19 patients the other night. When you see 19 patients, you do not do their charts on the way. So I spent several hours at home completing their charts. And that's a very regular occurrence. And I have 24 hours to get those charts in. So it's not something I can put off until, Friday. And then in addition, I have.
I'm going to stop you for a sec. So in a situation like that, that may be on the higher end, 19 patients and the number of charts you brought home, but you get home, you said 5 a.m.?
I end my shift at 5 a.m.
Okay.
On a, regular night, I get home at 5:30.
Okay, so you get home at 5:30. You would on that particular night have come home with a bunch of charts or something on a computer. And do you then turn to that or do you crash? Okay, so it's when you wake up after you've slept as much as you can, that you then do your charts.
Yes.
And that could be after your kids have come home from school.
Yes, obviously I like to spend time with my kids. So
I'm not pressing that at all.
I was going to say, I try to wake up early enough that I can get them done beforehand.
Okay, that's the goal.
Bring home 19. That's probably not a realistic thing.
Got it. So the work would be after you wake up, and it could extend into the time when otherwise Ms. Goldie might leave the kids with you, but she would stay later then, assuming she can, because you didn't have to go pick up these other kids, because you are needing to focus on the charts, which are due within 24 hours. And even though you love your kids and they want to climb all over you, they need to be somewhere else while you do that.
These charting obligations that you have, are they a required component of your job?
Absolutely.
Okay. And that 24-hour turnaround, is that specific to you, or does everybody in your particular type of position in the ER, do they all have to do that?
Yeah, we all have to do that.
Okay. And is your husband always available to cover hours that you might need to be charting?
No, I mean, he's really helpful and does what he can, but he, works 2 jobs. He's busy.
And are your kids always at school during the hours that you need to be charting?
No.
And do you also, in your opinion, well, is it fair to say that catching up on sleep is considered by you to be part of related to your work?
Absolutely. Like I cannot go into work super tired and see 19 patients and not make mistakes and, take care of people. And I don't think anybody would want that from their physician either.
And after you get off shift, do you have any concerns about your ability to drive well with the kids in the car?
Yeah, I mean, absolutely. Like it's, when I leave my shift, I am tired and sleepy, and to stay up for another 3 or 4 hours and drive my kids is not a situation I would like to be in or put them in.
And can your husband always cover the hours that you're trying to catch up on sleep?
No.
And are the kids always at school during the hours that you're trying to catch up on sleep?
No.
Do you need any other time that you can think of to share with the court where you need to recoup and refresh from working that you feel is related to your performance at work?
Yes. I mean, I also have not even recoup and refresh, but I also tomorrow I am teaching an ultrasound class at 9:30 in the morning, and I will need time to prepare for that and to drive basically all the way in here. That is not elective. We have a certain amount of things we have to do per year. I have CME that I have to do, a continuing medical education that I have to do in order to meet requirements for my job. And then I have just a lot of admin stuff like everybody else's job, that we have to keep up with, and meetings and stuff. So there's all of that. And then, selfishly, I take my 30-minute to 1 hour workout. That is my blow off the steam from yesterday, because my job can sometimes be kind of crazy. And, it is my leave yesterday and reset. And I think it's good for my job. I think it's good for the kids. It's been really good for me, and I would call that kind of my critical time too.
How many continuing medical education hours do you have to log?
I mean, I think I'm only required every year to do 30, but I do more than that.
You said 30?
Yeah.
And could you just
Sorry,
speak
I
up a
do
little bit?
30.
It's always hard after lunch. Everybody gets a little muted after lunch. And what are the teaching requirements that you have related to your position at the ER?
So I have to do, depending on what I choose, but I have to do at least 2 teaching presentations, and 2 helping with teaching. I just kind of do them all simultaneously. I choose to do them with the ultrasound department because that's what I did my fellowship in, and I like it.
Okay. And would you ever go to conventions separate and apart from the continuing medical education?
It just hasn't fit with the schedule with the kids and everything like that. But so I have not in a few years. I think I did 3 years ago. I went and did it, but I haven't since.
Okay. And have you had any fundamental changes to your work schedule from 2024 to present?
No.
And you agree that has your income gone up incrementally since 2024?
Yes.
And Your Honor, I'm just trying to move quickly at this point because I know we don't need to beat a lot of dead horses. If I could move to admit, if you could look briefly for me, Ms. Deal, can you look at what we've marked as Respondents Exhibit 9? It's in the smaller notebook.
Got you.
Is that a true and correct copy of your 2025 W-2?
It is.
Move to admit, Your Honor, Respondents 9.
Admitted?
And did we use your W-2 in part to calculate your income? Meaning, did we use Respondents Exhibit 9 in part to calculate your income for the purposes of your trial financial affidavit, which we've marked as Respondents Exhibit 8?
Yes.
Okay. So we showed, for example, if you could turn to Respondents Exhibit 8, which, Your Honor, I think has already been admitted as, I believe, P2 perhaps? Yes, as Plaintiffs 2. Do we show are you with me on Respondents Exhibit 8? On page 2, do we show your base salary of $305,000 a year? And then for the additional bonuses, commissions, overtime, we based that additional amount on what would be required to reach the total in your 2025 W-2.
Yes.
Okay. And if you could look at what we've marked as Respondents Exhibit 10, is this a true and correct copy of a relatively recent pay stub that you received in mid-July of 2026?
Yes,
Have you had any changes to your base compensation since that time?
I have not.
Move to admit, Your Honor, Respondents Exhibit 10.
No objection.
Admitted?
And is it fair to say that your income year-to-date is fairly consistent with what we have shown in your financial affidavit based on 2025?
Yes.
If I could move you also to, if you could please, Ms. Deal, look at what we've marked as Respondents Exhibits 14 and 15. Are those child support worksheets that we've prepared basically as demonstratives for the purpose of this litigation?
Yes.
Okay. And in Respondents 14 and 15, are the income numbers the same?
Yes.
And those are based on the financial affidavit information that both parties have presented to the court in this case?
Yes.
And do we also, in both child support worksheets, do we show on Schedule C parenting time days for Mr. Deal in the amount of 173?
Yes.
And on Schedule D, in both versions of the child support worksheet, do we show your child care costs as, I think the net figure is $3,683.33?
Yes.
And does that represent the required minimum rate that Ms. Goldie, that's the required minimum rate that you must pay to have Ms. Goldie work for you?
Yes.
And is that just I think it's a skosh over the figure that was contained in the original 2024 consent order. Do you recall?
Yeah, I think there was some negligible rounding for ease of math.
So if you go to Respondents Exhibit 1 and look at the child support addendum, I think we spent some time on this. If you look at page 4 of the child support addendum, I believe the nanny costs, if you will agree with me, are $3,655 in the consent order. Does that sound right?
Yeah, that sounds right.
So there's just a small difference between that and what we have shown in Respondents 14 and 15.
Yes.
And is the difference between Respondents Exhibit 14 and Respondents Exhibit 15 that in Respondents Exhibit 15, we are including the costs for childcare that Mr. Deal included in his financial affidavit?
Yes.
And that's in the amount of $1,500 per month? So in Respondents Exhibit 15, we show on Schedule D $1,500 a month for Mr. Deal. And the figure that we just went through before from Ms. Goldie in your column of that. And do we include in either version of these child support worksheets extracurriculars or camp costs?
No.
And did we do that because those costs were taken quote unquote outside of the worksheet in the original 2024 order?
Yes, that's fine.
And are you asking that His Honor keep the 2024 consent order arrangement in place, including the costs that are taken outside of the worksheet?
Yes.
And so we are asking that the combined amount between Mr. Deal's direct child support payment to you and his contribution to the child care costs be left at its current rate of $6,228 a month. And that's what's reflected in Respondents 14 and 15.
Yes.
Has Mr. Deal, we've already covered this, so I want to go quickly. Has Mr. Deal exercised any meaningful, amount of parenting time above and beyond what was in the 2024 consent order?
A handful of days.
Say that again?
A handful of days. 5, 6, something like that.
Can I turn to you, to refresh your recollection, if you could turn to what we've marked as Respondents Exhibit 17. Is that an affidavit that you prepared to present to the court stating the extra days that Mr. Deal has exercised since the fall of 2024 when this consent order was put together?
Yes.
And could you just look at it for a moment to refresh your recollection? So is it correct that he exercised about 2 extra days in November of 2024?
Mhm.
And about 2 extra days, yes, and about 2 extra days in July of 2025?
Yes,
1 extra day in September of 2025?
yes,
And about 2 extra days in January of 2025?
yes.
Do you, as you sit here before his honor, do you recall any other additional amounts of time that he exercised?
Sarah, do you want to admit that?
No, I think it's part of the, I was just having her refresh her recollection about it. Thank you, though. How long, well, I think we've covered this, but how long has Ms. Goldie been employed as a nanny for your children?
Like 3 years.
And do you agree that Lily was, oh, how old was Lily at the time that Ms. Goldie first started?
2.
2. And did you, before you hired Ms. Goldie the first time, meaning back in October of 2023, did you talk about the idea of hiring her with Mr. Deal?
Yes.
And how did that discussion go?
It went well. You know, it went well. We both were in agreement that it was time to transition from the previous nanny, and the pay rate was the same, so he was okay with it.
Okay. Did he voice any objection to her being hired, Ms. Goldie?
No.
Did he meet her as part of the interview process?
No.
Do you think having Ms. Goldie as your children's nanny benefits them?
Absolutely.
How so?
I mean, she's awesome. I mean, most importantly, she is responsible. I do not question their safety or their well-being. Like, that's obviously number one on any nanny. But then also, she is just amazing with them. She loves them. They love her. She plays video games with them, not in a way that she enjoys it. You know, they enjoy it as much together. She gets into their interests. She introduces them to hers. When the kids have a tough day, she sits down and talks with them. She is like a member of our family. She is reliable. She shows up. She works even if she's a little bit sick. We can communicate very well and effectively. She has rolled with a bunch of changes through this whole, you know, through the 2024 process. She has rolled with all of that. And it has provided a consistency to my kids that after the whole divorce process was really necessary and has been amazing and invaluable for them.
Now, you heard your ex-husband testify about, I believe, to sum up, that he was not sure whether Ms. Goldie would be available this morning to pick up the kids. Have you had any experiences like that where she was unreliable or unresponsive?
Never.
When you describe a situation like the kids had a tough day and she's there for them, I'm trying to balance that, not that she would be wonderful with the kids, but that she would be with them after school, with your testimony that maybe with the exception of one day, you actually take over once she gets home. So how is it that she is plugging in with them that way? Or when is she playing video games with them?
I mean, okay, so like, I had to work Saturday night. This, because obviously I did not work last night and I'm not working tonight. I had to work Saturday night. So, Sunday day, she's with the kids. They play video, you
Got it,
know.
because you work Saturday night, you're sleeping now Sunday day.
And then the summer she spends the 3 days with them.
Okay. Got it.
So, and she's not always a run right out the door.
No, I
No,
get that,
she's
but
not. So like, so if the kids have a hard day at the end of school and they were talking about it in the car, she'll sit and hang for 20 or 30 minutes
Okay.
and, you know, and talk to whichever one of them it was just about what's going on.
okay. You have described a situation that in my mind differs from what she described. I'm not saying people were making something up, but she made it sound like it was pretty routine, that she'd be there, she'd do dinner and this and that. And your description was, no, that wouldn't be it so often.
Like like, especially if it's a Tuesday, if she doesn't have the other thing, she will frequently stay, but I don't consider that like on the clock staying. She's just there.
She's hanging out with the family.
Exactly. And I mean, they're not wrong. She lived with us, not in the capacity of a live-in nanny, you know. We were moving, her lease expired. She's like, can I stay with you while I find, you know, somewhere? And we said yes, but it was not paid or on the clock situation. So she was around our house a lot for a couple months.
And I don't know that we need to stay on this for very long, Ms. Deal, but did Ms. Goldie supply hours during the summer when typically, meaning this past summer, when typically the children would otherwise be in summer camps?
Yes, yeah. If she wasn't there doing that, we would have had to use summer camps 100%.
And why were you using her more this past summer than maybe in previous summers?
If you looked at the number of hours she worked in the summer, there's, it's a lot, but that's why we do the salary so that she can work more in the summer. And then in other months, she doesn't work as many hours, but when you look at it all, it evens out to a pretty reasonable amount.
But the question was, why did Ms. Goldie work more this summer than in previous summers where there might have been summer camps?
So she worked basically the same this summer and the summer before that because everyone was in regular school. And then the other reason of that is in 2024, when the overnights went away, everyone recognized, like the four of us at the table were not stupid. All of us recognized that the number of hours that she was going to need to work to cover my shifts were going to be less. And so part of that.
The
was
overnights
moving
meaning
those.
the overnight she spent at your house because you were working.
Yes, because she.
And
was
now
studying.
they're going to be
She
with
originally
dad.
got hired. I'm sorry, I didn't mean to interrupt you.
Okay, I followed her, but now they're with dad instead of she's staying at home.
Yes.
Got it.
So part of that was because she wanted to remain employed as well. She didn't want to lose this job either, but that she would provide summer care during the summer, which, for kids, that's $425 per kid per week, $400 to $425 a week, that we would have been splitting in summer care for the duration of the summer, so that took a cost off of both of us. We also shifted from splitting that amount 70-30 to 50-50 to also kind of acknowledge and accommodate what was happening and what was changing.
Have you ever felt that you were overpaying Ms. Goldie?
No.
Why not?
I would say probably the very first 2 months after 2024, maybe I did because I didn't want to change her schedule at all because prior to that date, Kyle had never really had the kids overnight. And I was not sure that it was going to work. So I said, just stay on retainer with me for a month before we make huge changes. But after that, no, absolutely not. Because she provides a lot of care to the kids. I could not do my job or be the mom that I am to the kids without her.
And when you say Mr. Deal had not exercised an overnight, you meant a weeknight overnight,
Yes,
correct?
Before that, it was 48 hours every other week. That's all it was. He had not exercised his full summers yet or his full holiday schedule. So it was a very new and fresh thing in September of 2024 and a big change then.
And are we in what we've marked as respondents exhibit 14 and 15? And again, Your Honor, just for demonstrative purposes only, do we include a high income deviation on Schedule E of those exhibits?
Which one? I'm sorry, which one?
14 and 15, and I'm making you drown in the morass of family law world, but where you would find that is on Schedule E.
Yeah.
Yes.
We do.
And so can you tell His Honor, can you confirm for His Honor that the proposed high income deviation is $1,225 a month on Schedule E of 14?
Yes.
And it's slightly higher than that on Schedule E of 15. It's $1,548.
Yes.
With the purpose, of course, to support and we have incorporated those numbers to reach the $6,228 figure that is consistent with the current child support order, correct?
Yes.
Okay. And I think I might have already asked you this, Ms. Deal, and it's just because it's the afternoon, but do we agree with His Honor keeping in place the outside of the worksheet approach included in the 2024 consent final order, meaning each of you pays 50% of summer camps and 50% of extracurriculars, subject to a particular cap for Mr. Deal.
Yes, I'm fine.
And you are fine with continuing to maintain and pay for healthcare and vision insurance for the children.
Yes.
Do they have dental insurance?
They they don't have vision.
Oh,
They have
sorry, I said it the
health
wrong way.
And dental, they don't have vision. In November, we can talk, if we want to do vision. It's cheap, it's fine.
Okay, but currently you're obligated, I believe, only to provide dental and healthcare. Is that correct?
Yes.
Okay. And you're asking that Mr. Deal pay, to the extent possible, the recurring child support amount via ACH, meaning the recurring regular non-variable child support amount via ACH transfer to the extent possible.
Yes.
And are you also asking the court to award you your attorney's fees pursuant to 19615 K5?
Yes.
And have we put together a demonstrative and a demonstrative totaling your attorney's fees that we've marked as Respondents Exhibit 11, together with redacted statements behind it supporting the demonstrative?
Yes.
Move to admit, Your Honor, Respondents Exhibit 11.
No objection.
It's admitted.
And Your Honor, I would state in my place that the amount that she's incurred, this was as of a particular date, it's been increased since then as a result of appearance at trial. I think I checked my billing. Currently, it's right around, I think, 24,500, and that's before today. So. And I think I'm almost finished, Judge. I just want to make sure there's nothing else. That's all I have, Your Honor.
I'm trying to figure out, I'm still learning how the child support worksheet works. But 14 and 15, your exhibits,
Yes, Your Honor.
the difference between them is 15, I'm going to use the wrong terms, but gives Mr. Deal credit for his child care expenses.
Correct, Your Honor.
And adding that 1,500 instead, it actually makes his presumptive amount of child support goes down a little bit. He is on the hook for about 80% of that, but Ms. Deal is on the hook for about 20% of it, which is why there's a shift.
That's correct, Your Honor.
But then you just goose the deviation to get back to the 6,228.
Correct, Your Honor.
Okay, all right.
I mean, I'm not sure that the court necessarily has to reach its own child support calculation for the purposes of today if you chose to deny the relief sought based on a lack of change, but I thought that it would be helpful perhaps to the court to demonstrate what would happen if certain factors were placed into a worksheet today.
Got it.
Yes. And I do believe I'll just talk about the law in closing, Your Honor.
Okay.
Yeah.
All right. Did you have any redirect, Ms. Hanrahan Freitag?
Yes.
Okay.
That
So she called the witness? I mean, she's sort of crossing because she called the witness, but you have any other questions?
I do.
Okay.
I'm glad I laid it up, that's fine.
Looking in 14 and 15 in your
Big
exhibits.
one or little
small.
one? Okay. Sorry.
In both 14 and 15, you've included the cost of your nanny in the worksheet, correct?
Correct.
And you're aware that that increases the obligation for Mr. Deal.
Correct.
Okay, you're not asking him to pay $6,228 plus the nanny.
No.
You're asking him to pay $6,228 total.
Correct.
I don't want to lock you into things, but this doesn't include extracurriculars. You're not suggesting that it includes extracurriculars or whatever we do with summer camp, but it does include Ms. Goldie.
Correct.
Okay, I agree with that.
looking at Exhibit 4 of the big binder.
Big binder, hang on. Okay. Big
Towards
four.
the back is the child support worksheet.
Hang on, I'm just figuring out what 4 is. 4 is the 24. Okay.
Yes, and it's towards the back of that tab, the child support worksheet.
Okay. Got you.
All right. In that 2024 child support worksheet, there was an inclusion for the cost of Melanie.
You are faster at navigating through these. Can you give me like an A10?
Page 3 of the child support worksheet. I can come up and help. with
Thank
it.
you. No, it's okay. I just didn't want you guys to sit here while I dug through 4 pages, reading line by line.
You can see that there was an inclusion for Nanny Melanie.
Is that D1? Schedule D, number 1, the 6,383?
Yes, Your Honor.
Okay.
Yes.
What, if the total amount of child support was 7,878? Strike that. Oh, flipping the page to page 4. In the 2024 order, Mr. Deal received a reduction of $1,779.
Correct.
Yet you're seeking an upward deviation today to come to the same number.
The reason he received that downward deviation was my concession to the fact that we were keeping my nanny and that the nanny's work-related hours were knowledgeably going down. So we said, this sounds like a reasonable number between all of us. I said, we'll take a downward deviation on the amount that had been calculated based on our incomes. We said, we'll change the amount that we split it from, it was 70-30 then. Or it would have been 80-20, from 80-20 to 50-50. And we'll take summer camps, which were previously would have been 80-20 and made them 50-50. So these are, he spoke earlier to the concessions he made. These are the concessions I made plus the overnights.
Ms. Goldie receives 3 weeks off during the summer while the kids are with Kyle.
Yes, she does offer her services to him, but he has historically declined.
Okay, and you still compensate her $850 a week.
For her contract, yes.
Ms. Goldie, per her contract, gets another 2 weeks off per year, correct?
Yes.
For a total of 5 weeks, she's compensated at $850 with no responsibility for the children.
She has 2 weeks of vacation. It is up to Kyle whether or not he wants to use her on those 3 weeks.
In this past summer, he did not.
He did not.
The summer prior, he did not.
He has always chosen to decline.
He's traveling with the kids.
I assume some of that time, yes. That's just part of, that's part of having a nanny all year, is they will not stay employed for you if you're like, I'm going to go on vacation this week and I'm not going to pay you.
Mr. Deal has charting responsibilities as well.
Yes.
Thank you.
I have a question for you or Ms. McCormick, and you can both weigh in. If you look at page 5 of respondents 14, so it's the child support schedule D. Got that?
Yes.
And then the same child support schedule D from the September 2024 agreement.
Yes.
help me get from 6,383 to 3,683. Why is it almost $3,000 less now than it was then?
Your Honor, I think part of it is the 1650 towards the daycare costs that are no longer being factored into the child support worksheet. So back in 2024, Lily was in daycare, so that was partly why they put the automatic reduction in for 2024. I don't know that I have, I don't know that I can speak to what the other, I think the change seems to be driven perhaps partly by the Lily column, and my client might be able to answer that, but I know part of it is the 1650. That's, you know, I would respectfully submit was a contemplated adjustment that was already baked into the 2024 consent order, because once it went away, Mr. Deal's child support went down.
Okay, because the 3,683 is $850 a week, that you get that directly. So that I'm following, and it's just out of curiosity. I'm not saying, whoa, what's going on here? I had forgotten that in 24, there would have been daycare expenses, which would be work-related childcare for Lily. And I mean, maybe that is almost double when you add it all up. Or it was equivalent to a whole Miss Goldie, because the figure is almost, it's less than double, but it's a good chunk of that. Was there anything else going into work-related childcare?
Well, I got lost on what we're looking at here.
Sure. So if you are on,
Here, I see also I needed summer camp in the summer.
okay,
I needed summer camp in the summer, which we have, as we have discussed, is not cheap, because this would have been before.
it would have been all three kids going to summer camp back in 24 when you were,
Yeah,
okay,
back in
got it.
24.
And
Would argue that that is inaccurate because summer camp was an outside expense in addition to the base amount.
okay, we don't need to go too far down the rabbit hole. I just was trying to figure out how it was that high. And that's not a critical description, just it is 6,400 versus 8,400. So it's, I mean, 3,400. It's 30.
And we didn't,
700.
I mean, I said summer camp, but we counted what would have been nanny hours from basically 8 to 1, you know, whatever equivalent childcare hours that I would have needed then. Now that's covered in Melanie's salary, but the time we were making that, I had to calculate it all up. I think I'm like 99% sure that's why.
That's what went into the 6,400.
Yes, it may not have said 400 a week per camp. I think we tried to be a little bit more exact about it.
Well, and everyone agreed to it. I see, I didn't realize you guys have the same initials. 2 AKDs on the page. So you all agreed to the 6,400. I was just trying to break that apart into pieces to understand what else was in there besides Ms. Goldie. She is the 3683 that we see all by itself in Respondents Exhibits 14 and 15. And that's just 850 times 52 divided by 12. But I didn't know the origin of the 6,400. I don't want us to get further sideways. By asking that, did that come up with other questions for you?
It did.
No? Okay, great. Can Ms. Deal step down?
Yes, Your Honor, I know this is all kind of bonkers, and I also know that it's maybe driving my favorite court reporter crazy, but I just find it to be more efficient this way if the court's willing to let us do it.
It's much more efficient. I mean, we've heard from Ms. Deal now. She doesn't have to talk about it twice. You can step down, Ms. Deal.
Thank you.
You're welcome.
Sleep on this fine.
Okay.
Ms. Hanrahan Freitag, do you?
No.
All right. Ms. McCormick, do you have evidence you want to introduce beyond the answers you got to your questions and the exhibits you've admitted through the various witnesses?
I do not, Your Honor, and I do not anticipate calling anyone else.
Okay, then the evidence is closed. And I would love to hear from the lawyers, their argument as to what I ought to do and why. And I will ask questions as they come up.
I defer to Sarah.
Your Honor, thank you for spending so much time with us today. And going through the maze that is the child support worksheet and its various permutations. I think I would like to start, Your Honor, with quoting OCGA 19615H1. It's the definition of work-related childcare costs under the Georgia Child Support Statute. I will say, Your Honor, that every time I read the statute, I learn something new because it is so long. But in OCGA 19615H1A, it says work-related childcare costs necessary for the parent's employment, education, or vocational training that are determined by the court to be appropriate and that are appropriate to the parent's financial abilities and to the lifestyle of the child if the parents and child were living together, shall be averaged for a monthly amount and entered on the child support Schedule D. So I would respectfully submit, Judge, there is another portion of the child support statute, it's variable childcare costs to be taken outside of the worksheet, but the default setting that the Georgia legislature has set for this type of a case is to include the work-related childcare costs inside the worksheet. And that we believe work-related childcare costs are not subject to the extraordinarily narrow definition that Mr. Deal would have this court believe, which is you only get credit for the childcare that you're incurring for the seconds, minutes, and hours that you are actually at work. The child support statute has a broader definition than that, which particularly looks at the financial abilities of the parents, the lifestyle that they established while they were married, which we've had some testimony about, and certainly everything that is related to child support is supposed to be looked at through the lens of the best interests of the children. And so I believe we've had testimony today of what benefits Ms. Goldie in her 3-year relationship with the children has given to them, how she has supported their welfare, happiness, this consistency between households, but particularly in Ms. Deal's household. I know that the court understands, at least if you've watched The Pit, how demanding a job in the ER can be, and I think that my client has credibly testified about the work-related obligations that she has, such as charting and continuing medical education requirements that span beyond hours that she is actually in the hospital itself. We submit that the time that she spends catching up on sleep and self-care, those two should be fairly considered part of work-related childcare, especially under the broad umbrella that is set forth in the child support statute itself. Just to briefly, Your Honor, I know that we have come to court today to ask for an adjudication on the merits. We are not asking that you dismiss Mr. Deal's action on the basis that he filed improperly early, although that is still our position. We believe that the evidence has shown, and the reason we're not, Your Honor, is I learned, it took me a minute, but I have learned as a family law attorney, it's far better to make practical arguments than academic legal arguments when you are dealing with families and particularly with children. And so the reason why we want to reach the adjudication on the merits is because we do not want either of these parties to find themselves in court again in a number of weeks arguing the same things. We believe it serves both sides' purposes to just deal with the merits of the case today. But we do believe that the evidence has shown that Mr. Deal understood what parenting time he was agreeing to in 2024. It was very important to him, he testified during the course of the negotiations, to get the increased amount of time. And I believe that he has shown that he's a very smart guy. He can calculate how many nights he's getting under a calendar in addition to what was originally given to him in his divorce in 2022. And despite getting those extra overnights, that he was willing to pay the amount of child support that he agreed to. And he represented to the court that it served his children's best interests. And there were a lot of details in that 2024 consent order. It specifically said that my client would continue to employ the nanny, Ms. Goldie, and that she should be able to have either Ms. Goldie or her equivalent. My client has testified that she is paying the market rate for nannies to be available reliably and flexibly. They have to receive a certain guaranteed amount of income to occupy that role that really isn't tied to hours as much as it is to flexibility and reliability. And And Mr. Deal knew that because he agreed to the specific amount of pay in the 2024 consent order, knowing that he was going to get Sunday and Monday overnights added to his schedule. And I do believe, Your Honor, there are other portions of the child support statute, and I think it's OCGA section 19615G1, which demonstrates that the parenting time adjustment is meant to encompass the way in which a parent's expenses are increased by an increase in their overnights. And while it's calculated based on nights, Your Honor, I think really what the Georgia legislature was probably looking to is more so the daytime time. How are your costs day to day being increased by having children with you? If you have a 20-year-old son like I do, eating out of the refrigerator could make a significant dent in your household budget. And here, what Mr. Deal was supposed to have under the 2024 order that he negotiated with the benefit of the advice of counsel was to have these children delivered to him, fed and bathed. They sleep overnight. They're woken up the next day. He gives them breakfast and they go to school, which was supposed to be via Ms. Goldie. Ms. Goldie was supposed to be transporting them to school in his days, that he would get the benefit of that financial component of the 2024 agreement that he had entered into. So we submit that he has not had more parenting time than was contemplated under the court order. We believe that that section of the child support statute that gives an exception to the 2-year bar, the reference to the court order is the parenting order. And there are other portions of the Georgia child support statute that also reference that. I believe in the parenting time adjustment section, what it talks about is the parenting order, not the child support addendum. And I don't believe that Ms. Hanrahan Freitag will be able to present any authorities to the court to support the concept that the court order referenced in that portion of the statute was a reference to the child support addendum and not to the actual parenting plan. And again, that interpretation makes absolutely no sense if the idea is to account for certain increased costs that somebody would have from exercising more parenting time. And Mr. Deal has brought absolutely no evidence of how his expenses were increased by these additional nights per week. So, Your Honor, we respectfully are asking that the court leave in place the 2024 consent order that we believe was negotiated by 2 very educated people with attorneys who knew what factors to take into consideration to populate the child support worksheet. The parenting time adjustment, and I know the court can take judicial notice of this, the parenting time adjustment was in place as of July of 2024. This consent order was entered in September of 2024. It is true that there was a adjustment period baked in where it did not become mandatory until January of 2025, but it was nevertheless available to be considered and incorporated into the child support addendum and the child support amount had they wished to do that at the time. And not to be, again, a dead horse, but both of these parties now make more, not less, than in 2024. So we do not believe there's been a change in income or financial circumstances that would warrant an adjustment of the existing child support order. My client's work schedule has not changed. Ms. Goldie's required minimum rate, the evidence has shown, has not changed over a 3-year period, which is great. To not have childcare change over a 3-year period of time is a lovely consistency to have for a family. Mr. Deal's exercise of parenting time has not meaningfully changed. And I do think it's been a pleasure, Your Honor, to have a case before a court in a family law matter where there is largely agreement between both sides on many important numbers, including incomes, amount of parenting time days, child-related expenses. Really the only point of contention, it seems to me, between these parties, because they even agree that Mr. Deal has exercised the amount of time that he was awarded under the parenting plan. The only real issue in dispute was the amount of childcare that my client should be able to include in a child support calculation. And Mr. Deal agreed to that amount in 2024. He just seeks to undo that arrangement today. We believe that Ms. Goldie's services are appropriate to the parents' financial abilities and to the lifestyle of their children if they had been living together. My client testified that they have always used nannies both before and after their divorce, and that the rate of pay paid to the nannies was consistent with this concept that the nannies must be paid a certain required minimum amount in order to work any amount of time at all. And under that kind of idea, Your Honor, any amount of time that she works is work-related, because she wouldn't work for my client for a minute if she was paid less than what she's paid under the negotiated minimum rate, regardless of what sort of activities are happening during the times that she's working. I do think there's been some amount of time spent on Mr. Deal saying that he would gladly take over Tuesday overnights, and I heard, Your Honor, loud and clear when you said that you would be amenable to that sort of concept. It's nice to be able to have a parent take care of a child versus a third-party caregiver. But the nuance that I want the court to think about is the fact that Mr. Deal could have asked for that if he had abided by the 2-year bar, the 2-year prohibition, because you can only tweak parenting time once every 2 years. So if he had waited until September of 2026 to pursue this action, he could have, I would like that extra amount of time so that a parent could be caring for my children and not a third-party caregiver. But he couldn't wait, because what he really wanted to do was have the battle that he had already had in 2024 about whether or not the child care amount that my client needed was appropriate. And if he had just waited the 2 years, he could have tried to alleviate some of the aspects of need for childcare by eliminating that overnight shift, but he didn't. And so we are where we are today. I do believe, Your Honor, that to the extent that Mr. Deal's child support worksheet does not include the costs of work-related child care, that is not consistent with Georgia law. I do believe that if you don't have a variable child care cost, that you have to put it into Schedule D. And so we believe that you should reject his child support worksheet to the extent that it does not include work-related child care costs. We are not here to tell you that his $1,500 a month is not appropriate. I think if you listen to sort of the spaces between the words in his testimony, is he also highly values having a nanny who is both reliable and flexible. And we're not here to take any issue with that. We think that his $1,500 a month should be placed into a child support worksheet if some sort of recalculation is taking place. As for and I know these are sort of academic, because again, we're asking, Your Honor, not to change the existing 2024 consent order, but my demonstrative exhibits 14 and 15, do contain high income deviations in them. And I think what I would want to share with the court is those deviations, whether they're 1225 or 1558, I'm probably not remembering them perfectly, they represent 1% of Mr. Deal's gross monthly income. I think that Your Honor is going to see people come before you, probably in your tenure on the family law bench, where they make $70,000 a year and have 3 children, and they have child care for the 3 children. They, making $70,000 a year, are going to have to pay child support ranging from $1,500 to $2,000 a month. So we don't really believe that it is a huge stretch to ask that he, in order to sustain our argument that the 2024 consent order should remain in place, if we say that in order to reach that idea or to support that idea, we have to have a high income deviation in place that represents 1% of his gross monthly income, we really don't respectfully believe that that is much of a stretch. And
does the high income deviation make sense in a scenario where both parents would fall into what I think the casual observer would say is high income? One is higher, there's no question about that, but we don't have the scenario of a $70,000 annual income with loads of expenses. We've got a much higher amount. We've got 5x that.
well, I think, Your Honor, it's completely within the court's discretion, but I will say that if I'm recalling correctly, the child support guidelines, a high income deviation can only be used by the court if the combined income is $40,000 or more. So I think what they're really looking at is both parents and not necessarily the disparity between one parent and the other.
Okay.
Let's see. So, Your Honor, in short, I think thank you for spending so much time with us and for letting us leaf through our pages and try to make sure that we've asked you all the questions and entered all of the exhibits. Again, what we're asking is that the court find that there's been a lack of meaningful change to the party's income incomes or financial circumstances or the needs of the children in the sense of work-related childcare, and that Mr. Deal be left with the benefit of his 2024 bargain for at least another 2 years. And we are asking, Your Honor, and I know that the court, it's hard to get attorney's fees ever, Your Honor, in family law court, but we are asking that he be made to pay my client's attorney's fees in the amount of approximately $25,000, because we believe that Mr. Deal should be sent a message that this is not the place to come and serially litigate disputes between families, that the court's resources are limited, taxpayers' resources are limited, and that you cannot just willy-nilly litigate your interpersonal disputes when the merits of the case do not really call for that. And if the court declines to modify the 2024 consent order, then my client would be deemed the prevailing party for the purposes of the child support worksheet. And then, of course, Your Honor, you have the discretion to find whether or not the interests of justice would be served by an award of fees to her. And that's all we have. Thank you for spending the time with us today.
You're welcome. Question. We heard a fair amount about difficulties the parties have had in ensuring that money flows from Mr. Deal to Ms. Deal. And I don't, from the record I've heard, attribute that to anyone withholding money or playing games with, I'm going to pay you later, but they just haven't found the right mechanism. And so I'm going to ask Ms. Hanrahan-Freitag the same question. What do you recommend? Just shove everything through our family wizard because then it's one channel and it's just going to have to be in pieces? Or for the piece that's not variable, that would be the child support piece, that's the ACH debit or whatever we call it. I'm open. I would love to remove that burr from underneath the Deal parental saddle, because it's got to be frustrating on both ends. Mr. Deal's saying, I did what I'm supposed to, and Ms. Deal's saying, well, it didn't work. And it's not because he's trying to pay in pesos.
Right, Your Honor. Thank you. I had meant to raise that in my closing and forgot. Yes, I think it would benefit both families to be able to have a streamlined process for the payment. I don't think my client, I think she testified to this, I don't think she has any objection to the variable smaller chunks of reimbursement to the extent we still have reimbursement outside of the worksheet. I don't think she has an objection to that happening through our family wizard. I do think that for whatever reason, and we haven't filed a contempt on this issue, and there's a reason for that, but I think for whatever reason, if OFW is not perhaps the best, and I don't think it has been the best vehicle for the recurring consistent monthly amounts, then yes, we would far prefer that it go through an ACH recurring payment.
Okay.
And I haven't discussed this with my client, but if there's some issue about the amount, if the amount is in excess of what an ACH transfer permits, then I don't think my client would have a problem with one payment being made on the 1st and another on the 5th or something like that.
Okay. All right. Thank you.
And to pick up where Ms. McCormick left off, Mr. Deal testified that he had no objection to an ACH transfer for the recurring amounts and a preference for our family wizard for the variable amounts. So we may have a court on that.
I like a chord. And I'm not aware of there being a limit on ACH transfers. You can ACH transfer 100 million. I mean, that might be too much, but I don't think we're bumping up against numbers that would cause like the Treasury Department to swoop in and say, well, wait, this is money laundering.
That would be our hope, Your Honor.
Okay.
Your Honor, I want to pick up right where you left off, and that is in the 2024 child support worksheet is artificially inflated to the 6383 work-related childcare expense. That large inclusion artificially inflated the 2024 child support number and should be corrected. I'm here today. We proceed under the needs, the variation in incomes and also the needs of the children because the nanny expense is exorbitant. It should have dropped significantly from a full-time 36-hour overnight shift coverage to what is in place now, which is 20 to 25 hours per week. There should be a reduction for the cost of Ms. Goldie, and the fact that there wasn't is an independent choice of Ms. Deal. It shouldn't be the responsibility of Mr. Deal. speaking to Ms. McCormick's point, that childcare costs have to be appropriate to the parents, we agree. Our position is that the cost is exorbitant, that Ms. Goldie is working approximately half the time and earning the same salary. She has 5 weeks, 2 weeks of her own vacation, plus the 3 weeks the children are with Mr. Deal, that are paid and unworked, is more than most people in a salaried position have the privilege of. The offer that Ms. Goldie would come to Mr. Deal's home is perhaps disingenuous. She has never done that. That has not been their pattern. She just does those morning pickups and drop-offs.
Let me ask you a question about one of the first things you said, that the $6,400 figure from in the child support Schedule D for work-related childcare, that's in the September 2024 agreement. It's about $6,400. And you're saying that that was inflated and it ought to be lower. And of course, everyone is identifying it as a lower number in the new proposed child support worksheets. Ms. Deal then gooses the number back up with the income deviation. Are you saying you really don't disagree all that much? Do you have a proposed child support worksheet, or would you adopt respondents 15 minus the high income deduction? Given how everyone agrees on almost every figure, I would think yours. Why don't you guide me to yours?
Ours, Your Honor, does not include the cost of Ms. Goldie,
At all?
Ms. Rose at all.
Oh, right.
That's
This is
the
the-
outside.
And why is that appropriate to keep work-related child support, childcare, work-related childcare outside of the child support worksheet?
If it is not a double dip, if it is not an inclusion on the child support worksheet and then a separate payment for Mr. Deal, there is no objection to its inclusion in the child support worksheet.
Okay.
To your question, that would put us in alignment with Exhibit 15, less the high income deviation.
Okay, that's what I thought. That's very helpful. I think I see the two positions then.
The connection that Ms. Goldie has with the children does not go to the reasonableness of the work-related childcare expense. Ms. Deal is arguing for an expansiveness of childcare that accounts for her sleeping and getting ready for work. That isn't an accommodation for the majority of parents. They have to work, sleep, care for their children. Her unique schedule, that is her choice of a unique schedule, is what is artificially expanding the use of Ms. Goldie. I think the addition of additional hours in the last 3 weeks to Ms. Goldie's time were a direct desire to try and inflate those numbers to have them look more reasonable. That was not something that was done in the prior school year.
How do we work through the fact that Ms. Deal works night shift? You said that's by her choice. I don't know. The testimony is that she prefers night shift versus day shift, but let's assume for a minute that that's actually true. It's like I'm a vampire, whatever it is. She likes working the night shift. That choice would preclude any parent from getting support from the other parent for childcare during the day when the kids are awake because the parent has to sleep then. I think that's your argument.
Right. We think that it is an additional category of childcare that would not be necessary if Ms. Deal worked days.
And what's the evidence that she can work days?
None, Your Honor, it's her preference to work nights.
Okay. So if this were a situation, it's not this case, where the only job Ms. Deal could find is on a warehouse and it's the night shift, because that's where they hire. If you come in, you start on the night shift, no one wants it, so that's where you got to be. And so at least she's working. We celebrate that. So that income is better than no income, but it's got to be the night shift. In that scenario, would childcare for the kids because they're not in school yet, from when they wake up until when parent wakes up, would that be work related? Because the parent does have to sleep. We agree the parent has to sleep.
Certainly, we would suggest that, taking it back to the scenario with the Deals, the children are in school during the majority of Ms. Deal's sleeping hours.
Mhm.
We would argue that she is available at 1:30 or 2 o'clock to do those evening, afternoon hours.
Okay.
We have no objection to her using Ms. Goldie. We have an objection to being required to compensate Ms. Goldie for that.
Well, I understand. I would hope that this wouldn't be I don't like the way you live your life. That's not what anyone's saying. But what you are saying is you've chosen to live your life in a certain way that in your household necessitates the nanny to be around during hours when in a standard employment schedule household, you wouldn't need a nanny. And that choice of work shift, not to create a financial obligation for your client.
Exactly, Your Honor.
But in my scenario where it wasn't a choice, it was, this is the job I could get, the night shift at this warehouse.
My argument would be that you're sleeping well. Yes, there is a sleep period necessary during the time when the children are awake. But if the children are in school, that would overlap and not create a work-related childcare expense.
While they're in school, but there would be at least the window. What I heard is that Ms. Goldie basically works two primary windows. The AM window, where she is getting them to school if she's picking them up from Mr. Deal, or she's actually getting them ready and out the door if it's days where she's at Ms. Deal's house because Ms. Deal is asleep. That would be only a couple hours after she got home. So she's out cold. I don't know how hard she sleeps. What I've heard your pushback was on the afternoon part. Like, hey, you know what? Get by with whatever small number of hours of sleep that would be and go pick your kids up from school.
Much like she does on Friday, much like she did, she testifies that she occasionally does when she feels available to do it.
Okay.
The threshold requirement of coming back into court for a modification of child support was adjudicated by Judge Ellerby. She found that the number of days was significant enough to come forward. While the parenting plan established it, it was not simply a Scrivener's error that it was only listed at 117 days. That was part of the negotiation and it was inaccurate.
It was negotiated that 117 would be the number that shows up for the calculation of parenting time?
Yes.
I'm not disagreeing with you. I just want to look at the, because that child support worksheet was kind of pre-mandatory, but it may well have included a parenting time. It did, okay. And so for whatever reason, you weren't in the mix then, I guess.
Correct.
Mr. Well, no, but this, I'll make sure I'm looking at the right thing. Your exhibit 4 is the consent final order.
Correct.
And there's Judge Ellerby's signature.
Page 4 of 6 of the child support addendum. It's at the very bottom into page 5.
Addendum, it's not in the, okay. Okay, but then I misunderstood what you were saying. I see that there. It may well be a typo, but if it's not, how did that 117 result in have any influence on the child support worksheet calculations?
It was it is not an inclusion in the child support worksheet.
Okay.
It had to do with our overall discussions and negotiation.
I know you're having to rely on, I guess, what other people told you, but who benefited from the wrong number being included in the child support addendum? Because
Neither.
117 is not the right number. Your client was spending many, many more days and nights.
Projected to, yes, as part of this agreement.
Right.
Yes, it did not benefit nor hinder either party.
Okay. And if I'm understanding you correctly, you're acknowledging that that 117 figure, which is not in fact an accurate count of the amount of time, it understates the amount of time that Mr. Deal spent with the kids. that figure 117 didn't have an impact on the child support worksheet that yielded the amount that Mr. Deal had to pay.
Correct. They did not include an Exhibit C. It was voluntary at the time, and they did not do that calculation.
Okay.
They did include an inflated child support or work-related childcare expense in that worksheet that did have an final amount.
And when you say inflated, everyone agreed to it. So it was a jointly agreed inflated?
Yes,
Okay.
but inaccurate as well.
Okay.
To the extent there is a request for a high income deviation, we believe that's simply a workaround to get back to the same inappropriate or outdated number. We object to Ms. McCormick's point, it's the combined income being in excess of 40,000. Both of these people are exceptionally high earners, and we don't believe a high income deviation is warranted. When it comes to Ms. Deal's attorney's fees, we asked not to be responsible for attorney's fees. Mr. Deal appropriately brought his action and narrowly tailored it to the issues before the court, and that each party be responsible for their own attorney's fees. Thank you.
You're welcome. Oh, and I guess you started with your answer to how payments could be made, the ACH transfer for the fixed amount and then variable amounts going through our family wizard.
Yes, Your Honor.
Okay, so we are in agreement there. Okay, great. So here is how things will work from here. I need to digest all this, do some reading. I may have a question or more. If I do, Ms. Niles will get that email to both sides. It might be a question for Ms. Hanrahan-Freitag. That doesn't mean, Ms. McCormick, that you can't answer as well. The question will never be, write me a brief about X, but it might be, what are your thoughts, or do you have case law that supports this position? And you'll be given a chance to say, yes, I do, here it is, or I don't, but it's still a good idea. And that may be it's a good idea and there's not case law. I may have no questions. I also may have Ms. Niles send out an email that says, all right, here's where I've come down. I'm handing the pen to one of you to draft a proposed final order. Once you've done that, and you'll let us know, I need this many days to do it, that proposed final order will go to the other side, not to say that's wrong, but to say, hey, you know what, you said 117, it's actually 173, or you did your math wrong, it adds up to that. And then in Word format, it will come to me, and I'll take it from there. To the deals, I appreciate how much you care about your kids. I didn't ask if your husband brought kids into the relationship as well. No, but you've got an extra full house, and that's exciting. And when will it become officially a new household?
I think it's going to be next summer, but it's
Okay.
just because I want to be able to have some vacation.
Sure. Good planning. I encourage you both to continue to collaborate as you take care of your kids. They are going to get older and more aware of how you two treat each other. And so it's going to become all the more important that you do so, at least within their earshot and eyeshot, respectfully. You can say what you want to your significant other about your ex when they're not around, but when they are around, it's real important that they understand that you both want what's best for them, which you do. You may have competing views, but that doesn't mean you don't both want what's best for them. Their needs will change. They're going to become in some ways more of a headache. And it will be important that you back up the other when it has to do with using phones or how late you can stay out, et cetera. I'm not offering parental advice, just it gets complicated. I'm letting you know, if at dad's house, we can stay out till midnight. At mom's house, we have to be home at 8. And maybe you just do the average and everyone needs to be back by 10. you will have new challenges as you move forward. But I appreciate your dedication to your kids, as well as your service to people with medical needs. That's important work as well. Council, thank you for your time. I will be in touch through Ms. Niles, and you both need to make sure that Ms. Jordan is taken care of.
Thank you, Your Honor. Your Honor, if I may, I have, I'm hiking around Mont Blanc from September 2nd to September 15th. It is possible that there will be times that I don't have Wi-Fi, but otherwise, I understand that the court needs to have all emails responded to, and I will do the best that I can, given that I leave on Saturday, but I'm going to be not on the mountain for the first couple of days.
Got it. So Ms. Deal, practice pointer, don't have your lawyer talk about being in the French Alps in front of the other side who's being asked to pay for your lawyer's expenses, you know? Just, I'm gonna be on vacation cutting coupons or something like that.
Touche, Your Honor, but it's just unusual. It's a 50th birthday belated thing, so I'm not normally out of pocket.
Nope, and no one's gonna interfere with that trip, and Ms. Hanrahan Freitag will be patient about it, as will I. So we'll push things out as I am able to, and then you guys will be setting the deadlines. We'll go from there.
Thank you, Your Honor.
Happy to accommodate Ms. McCormick's leave.
Good. I trust you do the same for you when you hike around some fancy mountain in Europe. Anything else, Ms. Hanrahan Freitag, on behalf of your client?
Just, it'll be settling up with the court reporter and making sure she has the exhibits necessary.
Right.
Nothing else.
Same question, Ms. McCormick?
Your Honor, we'll be settling up and doing the same, and I don't
Okay.
have any other things for the court.
All right, everyone be well.
Thank you.
Thank you.